remitted the file to the department for some clarification. In the slush.
Yes.
And
Ask what has happened. Find out.
Okay. Maybe allowed to. In this matter, the stay order expires today. My lord, the matter has been fixed on tomorrow. Tomorrow, if the matter is kept in the list at the top, my lord,
The stay order lapses today.
today.
Why did you come so soon?
No, my lord, the matter appeared on 5th. Actually, I was sick and accommodation was paid by one of my friends who didn't know that tomorrow the order, interim order is getting.
So tomorrow,
Tomorrow at the top,
if it lapses today, it hardly makes a difference whether it comes tomorrow or day after. What is the interim order?
interim order not to publish the result.
Yes.
Interview has been held. This is the matter, my lord, your lordship can recall me that state rule has been challenged. State rule has been challenged to appoint principals.
Where is the interim order? Show us the interim order.
Interim order that is not with me.
Why it is not with you? Get a printout.
Last order I just
Get a printout. Come at one before rising. Yes.
Lordship, may I
Ma'am.
be permitted to mention a matter?
Ma'am.
Lordship, this is a new motion matter, Your Lordship. I'm praying for inclusion in the
Group
list.
6.
Lordship, this is for appeal, Your Lordship.
Arising out of which group matter?
Service matter, Your Lordship.
Give it. to-
Also, Lordship, I was praying if
Monday we'll have it on.
Monday date for the.
My lord, I am for the writ petitioner respondent. I am led by Sumita Soy. Duty is in the sick come to Ramal. I am praying for not this week.
And come. One. You're for the bank.
On such a date, your lordship matter has been called and due to on the plague, but not reached lordship's court, and due to that reason, your lordship matter has been dismissed for default, your lordship. And application
There is
has
an
been filed-
application for restoration.
restoration and has been filed within time, your lordship.
What is the number? Can number?
And number 4, your lordship.
Yes. When it was dismissed?
On 4th.
Lordship, it is dismissed on 4th September 2024.
File with the
What is that?
What is the issue?
Lordship, actually, issue is the lordship more than 100 of crores, your lordship, involved in this matter. Transaction has been
Amount is not relevant. We are asking you what is the issue. No court is enamored by such figures. It is pointless to say 100 and 1,000 crore. Yes.
actually charge sheet has been issued to the writ petitioner on your lordship. 5th
No, there is a punishment.
lordship punishment has not been made out, your lordship. Charge sheet has been issued, and before charge sheet, lordship, one FIR has been lodged before the CBI, and due to that reason, your lordship, the after issuing charge sheet, respondent writ petitioner filed a writ petition before this honorable court, your lordship, and on honorable single bench, your lordship stayed the further proceeding of the
Proceedings of the departmental proceeding, yes.
in the year, your lordship, 2010, your lordship, 2010, your lordship.
Then what happened?
Thereafter, your lordship, I am still waiting, your lordship, and
What happened in the meantime in the criminal trial?
lordship, that is pending. At this stage also, it is pending, your lordship.
So
And in
for-
definite period, your lordship,
what is the date of the charge memo?
lordship, date of the charge, is, lordship, 5th June 2010, your lordship, charge sheet has been issued.
If June 2000. If June 2010. They granted.
There will be something else.
No, this. Recognition points.
What is the stage of the trial?
Regarding that, further, I have no knowledge about that case, but the case is still pending, your lordship, in the stage of trial, your lordship. That is not,
What is the stage of trial? Whether witness is over?
no, your lordship, it is not over.
One line of law is that you complicate the issues of fact without evidence. Then, before the criminal trial is concluded, the accused cannot be expected to disclose the difference in the department proceedings. Probably much more than the amount of the station. So it's simultaneous. But since it has been let us find out what the evidence. There's nothing we can do to then at least setting the state.
So we'll restore it and you give us the exact status of the trial today. Then we'll proceed further.
No doubt, but your lordship, by humble one sort of submission before your lordship's wisdom, that the infinity period, the
What did we say? We said we are restoring it. You come with the latest status of the trial, and then we'll consider. There's no question of infinite and fixed time. That is not an issue today.
Lord,
We want to know what is the status. Whether you have pursued the criminal trial diligently for the last 13 years, what have you done in the trial? We want to know whether your evidence is over. If you have not appeared, if nobody is appearing, then what will be done? We don't know. Come with the status. We don't want to prejudge anything. You show us what is the status today. More than a decade, the trial is pending, and still you are seeking vacating the stay of the departmental proceeding. Yes, you are for the petitioner. We are fixing it. You also find out the status of the trial. Both of you get the instruction. Give your appearance. March 2010. List after 3 weeks. You come with the status, then we'll proceed. Those matters are on list today, perhaps. This is item number.
That is one is
2 and 3.
two and three, your lordship. That is previous STA application and others, your lordship.
This was the must have been, but it is new. Appearing in the list, that's what the date of let us see. দেখে না যে কেমন ডিসপোজ হবে যেটা তো তাহলে ওগুলো রেস্টোর হবে শুধু অ্যাপিলটা
I beg to appear, my lord. My lord, by the last order, my lord, please to send down the file to the department for obtaining certified copy. We applied for the certified copy, my lord. It has not been made available, and since the matter is fixed and department has sent this file to this my lord's court. So my lord, once again, it may be because I have to.
When did you apply for
My
this?
lord, on the 31st. Here's the requisition, my lord.
Still not made available.
31st.
See, on 29/7, we sent it to the department. On 31st, he has filed.
Perhaps in my lord's order, it is not, my lord, specifically mentioned for the purpose of certified copy. That is why perhaps my lord, the department has.
Not issued a certified copy. All the concerns. We'll take it up after a while. After, while I'm asking why the certified copy was not made available for 10 days. Who is responsible?
Number three.
That's the copy of the application.
I find no system. Right. I don't take it. I take the top man. I say yes. No. Something wrong is going on in your department. Take care. Find out the details.
Yes, may sub notice upon the officer and government period. Last occasion, you also I prayed for time, and nobody appeared because that the matter of 2025.
Let's
24.
let us proceed. Let us proceed. Yes.
Yes. Lord, the petitioner is the eldest son of the deceased, eldest daughter. Eldest daughter of the deceased.
Eldest daughter
Yeah.
of the deceased government employee.
Government employee.
Yes.
They
What is the date of demise?
1997.
No, date, please. 5597,
1990, yes.
55.
Yes.
And when
17th March 1997.
Huh?
And the immediately,
Perhaps not.
in November 1997.
5597.
Yes, yes, yes. Date of, no. Date of the 17th March. 5th May 1997 is for registration. Date of registration. Can you see page 17?
And what is the date of death?
Date of the 17th March.
All right.
It is a-
Date of registration for what?
Death certificate.
Oh, date of registration of the death.
Yes.
So that is not a relevant.
That is not relevant. To the mother of the petitioner, though I have not annexed that copy of the application, she made application on 25th May. It's the affidavit opposition. The state has used an affidavit opposition. He has annexed. That's page 15 on 25th May 1994 for employment of her son. But they did not give me any response to that application. Then son, he left the house. Thereafter, she applied in the year on 4th December 2000. He applied. That application I annexed with the affidavit opposition, page 16, for appointment of her daughter, first daughter. And since in the meantime she married, the authority concerned rejected her application. Thereafter, the mother on 24 June 2009 applied for an affidavit opposition. Appointment of her eldest daughter, the youngest daughter, sorry. Now, if you come to my application, page 18, that is dated 31st March 2010. Now, can you see, my lord? An interview letter was sent to the petitioner. Please inform that the letter was given to from SRP Sialda to IC Noihati PS. Please inform Mousumi Haldar, daughter of deceased Nityananda Haldar of GRP Sialda, who reside at such and such, to come to reserve office, Domdom Road, such and such, on 8th April 2010 at 10:30 hours. Repeat, on 8th April 2010 at 10:30 hours, along with all testimonials in original for recruitment of Group C post in West Bengal Police under exempted category, most urgent. The next page, the type copy, page 19A. That is from OCRB sub SRP such and such to North Tourist Organa. That is also, please inform Mousumi Haldar. This is Haldar, daughter of the deceased Constable Nityananda Haldar, Sialda, who resides at such and such, under your police station jurisdiction, to come to Reserve Police, RPF, Roman 2 section, such and such, on 3rd February 2011 at 11 hours, 3rd February 2011 at 11 hours, in connection with recruitment of LDC post in West Bengal under exempted category, most urgent. That is 16 May. The next page, that was in the year 2011. The petitioner appeared along with all testimonials. Then on 2018, next page, page 20. But this is a West Bengal Police Directorate, Bhavanimur, the present status of file number such and such, 28 March 2018. The proposer for employment to the post of LDC under exempted category in West Bengal Police Department in respect of Mousumi Haldar, daughter of ex-constable Sir Nityananda Haldar of Sialda GRP, has already been sent to Assistant Secretary Home and Hill Affairs Department Police Established Branch. Court Road, Navarno, Howrah, such and such, by memo number such and such, dated 14th October 2014. The selection made 2011, my lord, for necessary approval order of appointment. That means when a selection has already been completed for giving appointed to the petitioner on exempted category. That is, my lord, 2018. Now, my lord, next page, page 21, 18 July 2019. It's a letter of Joint Secretary to the Director General Inspection of Police. Here that has been rejected. With reference to the above, I am directed to state the proposal on the noted subject has been examined in the department in the light of notification number 251 EMP dated 3rd December 2013 of Labour Department, read with subsequent amendment made time to time and the relevant case record. It appears that the candidate has not fulfilled the required condition as laid down in the said notification for being eligible to be considered for appointment under the exempted category. Candidate in this case was only 12 years, 10 months or 9 days old at the time of death of the deceased employee. So the instant proposal is barred by the law, Labour Department approaching notification, read with subsequent amendment till date. Accordingly, I am directed to state that the government regrets its inability to approve this case for appointment under the exempted category on compulsory ground in the light of the guideline contained in the Labour Department notification and such, read with subsequent amendment. The issue with the approval of Home Secretary, Home, Hill and Hill Department Government of West Bengal, there is also, I think, said for safe preservation, such and such. Thereafter, around 2019, 7 next page, the Superintendent of Police, Government of Police, informed the Mousumi Haldar on the basis of our application, the photocopy of memo under reference regarding your employment under exempted category, wherein the government has regretted its inability to consider your case for appointment under exempted category, stating in the light of guideline contained Labour Department notification such and such, the 3rd December 2013, and date with subsequent amendment is being sent to you for your information. But that was on 7th August 2019. Again on next page, similar information was given to petitioner 17th February. Now, in the meantime, you also that the COVID period started, my lord. She could not challenge that order. And they moved the tribunal. The tribunal directed to.
What are they doing? They have not given 14 days. Huh? After we say. It takes you more than 10 days.
Move the tribunal. The first one, page 24. The tribunal, the Lani advocate was paid for time to submit the reply. No reply was filed. That application has been rejected. I have challenged, my lord.
So the younger daughter's application was rejected when?
2019. 18.
That is the order under challenge.
19. That order has been challenged. In the middle of the 2 years, that period, lost COVID period, they could not.
When you filed the OA?
2022.
2019 rejection challenge in 22.
After 1 year, thereafter COVID
What is
period.
the date of rejection?
Date of rejection, my lord?
18/7/19.
No. That tribunal application.
18/7/2019.
19. And they took time for 7 years.
So
2011, 7 years.
that will not amend the Administrative Tribunals Act. The Administrative Tribunals Act will remain the same.
Yes, it is the same.
Yes.
Now, my lord, immediately in 1997, the mother applied. That they did not respond.
Things.
Yes.
One is this July 2017, July 2019 order was required to be challenged by January 2021. 1.5 years.
Yes. There are not.
Even less than 1.5 years.
But COVID period, but nobody that your losses knows that.
COVID period comes 1 year after this, almost 1 year after.
1 year.
Yes. This is
No,
a
20. 20, I think March.
Yes.
March 20.
Perhaps 23rd March
20. 20.
Yes. Anyway, that is immaterial.
That is.
That is immaterial.
But immediately in 2022.
But you never.
But within
challenge-
22, but
You never challenged the rejection of 29/2008.
2000?
29/2008.
8.
The
Election
unfortunate demise took place in 97.
proposal.
Please, the unfortunate demise took place in 97. Mother applied for the son.
Yes.
Son thereafter walked out of the family in 2007. Then she said, give to my elder daughter.
Editor.
Elder daughter's claim rejected in 29/2008, not challenged by you. Then you give a third application.
Because
Now you are challenging the third application.
Yes.
Since you are not challenged 29/2008, can you maintain the prayer in the original application?
but not sympathy regarding why I was called. The petition was called. You are selected. Selected.
We are not asking whether you were called or not. We are asking in absence of challenge to 29/2008 order. Can you claim the relief?
The mother, according following from me, Ross says the mother ought to have challenged because I am the youngest. I have no application based on my for the petition as well. But it is not the
The
case.
benefit of compassionate appointment is for the family, not for an individual.
No.
There is oneness of claim between all the dependents.
Yes.
It is not me and he and everybody has to give a consent. Everybody has to give an undertaking of maintaining each other. So there is no individuality in this. 2 applications, first of the elder son aborted because he walked out.
Yes.
Second of the elder daughter rejected, not challenged. Application for the younger daughter challenged. Can that challenge sustain? Tell us. Only this much. Then we'll see whether she was called for the third 3-member committee has given a report, whether all these things will inure to her benefit or not.
When I go to the can see page 20 of the affidavit in opposition.
Yes.
Page 20. You got it, Manu?
Yes, what is it?
With reference, the letter was given to the Superintendent of Police to the Inspector General of Police. With reference to the above, I am sending here with the fresh inquiry committee report covering the present financial status of family of the deceased constable Nityananda Haldar of Sialda JP district and division for delayed submission of proposal for employment under exempted category of Mousumi Haldar of deceased. It is mentioned that Nityananda Haldar of Sialda JP district expired on 17th March 1997. During his life, Srimati Kalyani Haldar, wife of deceased Nityananda Haldar, submitted a prayer for employment of her elder son, Gorachar Haldar, for the post of constable in West Bengal. So he got him again. Within 6 months, then there is a whole
separate the rejection of compassionate become easy, but
Jo.
oh, sorry. It's the condition. So legal cannot that are photo neither it can be challenged. If at all you are able to challenge the first, then challenge
And read it.
You have no case,
But you have gone through it, but can I read?
not required. We are not concerned with what the committee says. The committee is holding you eligible will not be prevail over everything. That is one of the process in the recruitment process.
But they started,
One of the stages in the recruitment
process
process.
was started when that letter. That is their own letter.
Very well.
Sorry, follow
See, we are repeatedly asking you one question, you are evading that question.
2008.
If you have not challenged rejection of the first elder daughter, can you maintain a second application or challenge the rejection of a younger daughter?
That is why I am reading this letter.
That will not help you. You have to tell us whether it is permissible.
Satisfied or I can't read it. I am reading.
We have gone through it.
You have also gone through it.
We have gone
After
through.
2008.
Yes.
After this.
Yes.
Face inquiry could report in connection with property.
Correct. So therefore, on that
Kindly
basis,
be considered on sympathy.
very well.
Purpose of compulsory appointment.
So the second daughter's application has also been rejected.
Second application rejected. Yes, 2019.
19.
Second application. Immediately after that COVID period, or your office no, thereafter
All right, that is over.
that is over.
Yes.
But my submission, he was selected, he was. Only for approval, he was recommended only for approval, that was it.
What is the date of that recommendation?
What is the letter of?
Date of recommendation.
Oh, yes. That is, my lord, 2019,
Give the date, please.
16th May 2011. That will be 11.
No. You are reading the recommendation of the younger daughter. What is the date?
Oh, 5th November 2012.
No, it can't be.
No. One can't say 2020 affidavit in opposition, that is their letter. They have annexed.
Which page? Which page is
Page
it?
20 of the affidavit in opposition.
That is what you are reading.
Yes.
This is for the younger daughter.
Yes. Mosumi Halda. Proposal of the second paragraph, last line. Proposal for of Mosumi Halda has been sent to your good office by this memo number 5th May 2010.
All right. We have seen it. So it
Under
may be
the
considered,
report-
may be considered sympathetic.
Yes.
And where is
They
the
are not-
rejection? Where is the rejection order?
Then when the next page 2019, the superintendent police informed the Mosumi Halda her application that has been rejected.
simple definition. For implement of this, we have done with simple assistance of sheet.
He is relying on this. He says that this was recommended by the superintendent of police. Where is the final rejection order of 2019?
Final rejection order 2019-18. Yes, page 20.
20.
My application, page 21. That was not sent to the petitioner, but the joint secretary sent to the director general and inspector general.
Very well. That's all. Anything else you want to argue?
Then, my lord, it was informed to the petitioner by superintendent of police on 7th August 2019. 7th August 2019. And 7th August 2019, if I want to challenge that order that was sent, I will get 1 year before the tribunal. Within COVID period, I got it. I could not. Thereafter, my lord, in the year 2012, immediately after completion of the 2 years, my lord,
Your OA has been rejected on limitation.
no,
Then why?
not limitation.
Rejected on merit.
On the minor.
Therefore,
All the minor at the time of death of her father, she was minor at the age of the 12 years such and such, that is why rejected. Not on the limitation.
and your case is that there was a proper recommendation. Therefore, she should have been
She has
appointed.
been selected also.
Heard the learned advocate for the
And number 4,
So, my lord, my lord, officer asked, they will provide within an hour.
Come back. Before we rise, you come back.
they can do it.
None appears for the
And 5,
not today.
and 6,
That I am for the petitioner, my lord. That is the regarding compassionate appointment to the minor child of the marriage second wife.
What was the age?
That is age, my lord, 4
At the time of demise.
and 2 children,
Huh?
4 and 2,
4 and 2.
and no other source, my lord. 2 is under treatment. 3 major surgeries has been done.
And the mother?
Mother, my lord, applied for a compassionate appointment and heavily pension on behalf of the minor child. So on behalf of the 2 minor child,
If the mother didn't apply for herself,
mother, his mother is the second wife. Mother is the second wife.
where is the first wife?
First wife applied and first wife is getting pension. Everything he is getting, my lord. And first wife is deserted, my lord, since last 14 years.
First wife is?
Deserted.
Has the first wife applied for a compassionate appointment?
Yes, my lord. Applied for.
Did she get it?
Yes, my lord. His appointment is processed, my lord.
She has got it.
Neither till date she has not got it. She has not got it. Till date. Well, on the other hand, my lord, there is no other source of income of the second wife's minor child, my lord.
You have implemented the first wife as a party.
Yes, my lord. Everything paper book has been given.
She is appearing.
Yes, my lord. And in a handwritten letter, my lord, the deceased employee has told everything, and thereafter the matrimonial suit, divorce suit was filed by the deceased employee. Practically, second wife, along with his 2 children, my lord, are in street beggar. Half of the retirement benefits has been paid to the second wife on behalf of the minor child, 2 minor childs. But so many dues has been still are payable to the second wife. No. Lordship has already held that the 2 minor children are entitled to pension, heavily pension, my lord, equally. Paper book gulo din. Only application.
Yes, who is appearing for the first right? Bishop. Who is appearing for respondent? Private respondent?
Private respondent, Mr. Biswarup Nandi. A matter was sent to the mediator, my lord. Mediation also failed, my lord. My lord, second wife is not intending.
Biswarup Nandi is for the private respondent number 6, my lord. Because some difficulties he couldn't make it, my lord. Can it be not this week? Or my lord, next Tuesday, if you can. I'm being told, my lord, there's a dispute. You lordship will send the matter for, my lord, conciliation. Conciliation process failed. My lord, this is what I know, my lord. I know nothing more than that.
The miserable conditions of the second wife and his two
We are
children.
fixing it with the time.
As well.
We inform him that it will be taken up. It's been pending. And whatever is due, either it should be given or she should know that she will not get it.
As well.
What is your stand?
Now, this matter is not with me anymore. The lordship,
Not with you.
it's with the Mr. At the previous
Earlier, in the earlier occasion,
You allotted.
in the earlier occasion, time was paid for from the state that the learned DP would appear.
Yes, initially I had appeared
But-
because the facts I remember.
But the fact remains, my lord, the learned government leader did appear on behalf of the private respondent.
Right.
It appeared on behalf of the private respondent.
Who?
Learned government leader.
Earlier he has appeared.
On behalf of the private respondent. No, order, my lord, order also, my lord, says to that.
Yes, he has appeared. We have seen it.
In the earlier occasion, my lord, time has been paid for his appearance.
16th February order.
I'll bring that to his notice, lordship, if the junior appears, Mr. Singh is there assisting him. Or otherwise. Now, as of now, the brief is not with me.
The final major operation is going to be held in the coming month, my lord.
The children are entitled from the second round. I think that is.
But in this brief changing business, the
It is
children are suffering. Therefore, we are
I
complaining.
understand.
We can't permit you to do this in
I'll
every day.
just inquire who's there.
So who will appear? You tell us.
I shall speak to the learned.
Find out. Come back to us at 1. Ask
Sure.
someone to find out.
Sure.
Be here before at 1 p.m. You see. We'll record who has to appear. We'll fix the date, please.
As well. At 1 o'clock, my lord.
Yes, 1 o'clock.
Hello, 7.
Same order. Dismiss. Last date is 29/7. Same day.
Ramesh.
Item number 8, my lord. I'm for the petitioner, my lord. I'm paying for accommodation, my lord. My lord, advocate and record, my lord. He's on legs, my lord. My lord, may kindly keeps it on the next Tuesday, my lord.
Not today.
Great.
09.
9, my lord, I am praying for not this week, my lord. Mr. Advocate on record is at illness. Due to his illness, he has not come, my lord. That's why I am. Next Monday or Tuesday, any day, my lord.
Copy is served.
Yes, copies.
There is a
হ্যাঁ আমার নামই দিচ্ছে
Thank you.
Para 10.
I'm for the petition.
Lordship, in this matter, I had spoken, Lordship. Lordship, this finance is still, the stand of the finances, Rule 36 is there. Therefore, they cannot go beyond Rule 36, Lordship. Therefore, your Lordships will decide on what to do. Because
no, not Rule 36.
Rule 36, Lordship, the shortfall of service, Lordship, where they were all, this Lordship, this was relating to the
That is. Where is the question of Rule 36?
So with the DCRB route, what is a qualifying service and how much we can condone? Up to 6 months, we are empowered.
Who has prayed for condonation?
Lordship, here, this is the question of qualifying service. She was short of.
So every issue for qualifying service will depend on 36. Perhaps what we are trying to say is not being communicated properly. There is an order of there are 3 orders of the Supreme Court.
I have been informed that.
Last day also you have examined it. You said
Yes,
I will
Lordship.
speak to them.
Lordship, I have.
What is the matter about 36? There is no matter about 36.
That is what has, by the feedback that has come to me, Lordship. I shall again, Lordship, if necessary, I shall.
You ask the finance secretary to assist us. Come to court.
Lordship.
Yes.
It is better.
Yes, Lordship.
It can't go on forever.
They are
It
saying
can't go on forever.
Lordship, that would clinch a number that there are plenty of matters.
How
like
can you do this?
No, Lordship.
That before one forum you will take one stand and before another forum you will
the
take
Lordship
another.
clarified in 27th of January's order.
Yes,
And
Lordship.
that too
Lordship, we have
directing for filing an affidavit too.
spoken, but
Have you spoken to him or you have
I
spoken
don't
to
know.
not, we had sent word, but
That
he
is the
has
whole
not.
problem.
That
That is the whole
yes.
problem.
Then Lordship will kindly let him appear virtually. Let that be. I think that is a better proposition because there are a number
Despite
of
earlier adjournment.
That it is to be complied with by giving pension.
See, that's why we said we can't. If the secretary
Monday week.
24.
Monday week.
24.
24. ठीक है.
I'm so grateful.
All such matters when it is taken up, you
There are,
tell us.
If it is
I know there are a
coming
number.
from the honorable
Yes, I,
General Secretary, then thousands of matter will be resolved. I believe so.
yes.
We need not come to the court.
No, that is.
It will,
Lordship,
There must
my
be a
little-
way of solution.
Lordship, my little experience just for
Yes,
these
she
few
has
months,
a wide
it is-
experience to that effect.
I don't, but whatever experience I've gathered from
At
you,
least 100 matters this type of,
Lordship, there are a number.
and they are waiting.
futile.
Yes, I understand, Lordship. That.
I see your office should prevail and something positive should come out.
Yes.
Everybody's interest.
Yes.
The court's time is wasted writing the same order every day.
At least your lordship dispose of 50 matters. I believe. I have that instruction as well as that.
Disposal. We are worried about the persons who are
The,
waiting.
who are
on
the
Yes.
flight of the.
Yes.
Yes.
And my clients are around 20 years waiting in the queue.
No, thank
They need not come.
The fixation on 24th,
Please,
sir.
I should.
24th.
24.
24, all such matters when they come up, you tell us, it will come up on 24. There are more matters today. There are more
There
matters.
are a,
আজকে কি মাথার আছে আপনার তাহলে আজকে দেখুন
Call it as and when it comes.
Yes.
Such matters which arise out of Geeta Naskar case, they will now come on 24. Make a note somewhere.
yes that will be resolved in one order.
it অন্য matter.
I'm so grateful to you. And এটা রাখ এইভাবেই রাখবি বার করে দিবি Yet.
16.
Lordship, Mr. Joindranayan Chatterjee is appearing for the petitioner, Your Lordship. I am praying for a day's accommodation, Your Lordship.
What remains? The payment has been made.
Lordship, a day's accommodation, Mr. Chatterjee is appearing before the learned court. Grateful, Your Lordship.
There are 17.
Lordship, this is also related to the matter of qualifying.
11 to 15. None appears for the writ.
Eleven to 15 হবে না আজকে
হ্যাঁ হয়নি দেখেনি তো নট টু লেখা আছে 17 number 17 18 item 18 my lord in the last matter I was here my lord I could not follow my lord
17 ওটা
delete from the earlier order delete none appears
In my lord, this is my application, my lord. 18. This is my, I beg to appear on behalf of the applicant, my lord. This application is arising out of an application filed by the petitioner, whereby the petitioner has prayed for disbursement of his ADR all retirement benefits. The petitioner is working as a medical officer in anesthesiology in the Murshidabad Medical College and Hospital, my lord. The petitioner joined in the service in the year 3rd July 1989. He retired from his service 30th November 2021. After the date of retirement, my lord, 1.5 years have elapsed. No retirement benefit, including pension, was disbursed in favor of the petitioner, my lord. Therefore, the petitioner was compelled to file an application, original application before the learned court of State Administrative Tribunal. My lord, kindly see the order impugned in this application. That is page 122. Kindly come to page 122, annexure P 10A. The matter is taken up by the single bench pursuant to the order contained in the notification such and such dated 23rd November 2022 issued by the exercise of the power conferred under section 5(6) of the Administrative Tribunals Act 1985. Mr. Sunita Agarwal, learned counsel, files a report in the form of a correspondence addressed to her by the Deputy Director of Health Services Administration in his memo number such and such. Copy be kept on record and copy be served upon such and such learned counsel for the applicant. Submission of Mrs. Agarwal is that, as evident from this communication, the departmental proceeding against the applicant has concluded and instruction has been passed to the Superintendent District Hospital, Barampur, Murshidabad, to disburse his pensionary benefit after final clearance from the vigilance wing of this department. The such and such learned advocate, having gone through these letters, submits that a direction may be given to the respondent side to sanction and release his pension and other retirement benefit expeditiously. Having heard the submissions of and learned after considering the new development of the light of the correspondence mentioned above, the respondent number 9 and 10 medical superintendents cum vice principal Murshidabad Medical College and Hospital and the superintendent district hospital Barampur Murshidabad respectively are directed to ensure proposal for pension and other retirement benefits are completed and submitted before the principal accountant general West Bengal within a period of 60 days from the date of promulgation of this order. My lord, the 60 days has been lapsed. The order was passed on 23rd December 2024. My lord, 3 or 4 months lapsed, no retirement benefit was disbursed in favor of the petitioner, my lord. Thereafter, the petitioner made an application before the concerned authority, whereby he was for the first time, no communication was made, my lord. The first time it was came to the knowledge of the petitioner that the accountant general concerned forwarded a letter to the concerned department, to the Murshidabad superintendent and vice president of the Murshidabad Medical College, seeking clarification the period, what are the regularization of the ad hoc period, and also he is entitled any benefit of 8 years, 16 years, and 25 years in a cash advancement scheme. So I have partly agreed, my lord, because the pension has some amount has been disbursed, but no retirement benefit. That was that.
How it can be raised? This is the order under challenge. What is wrong with this order? Tell us.
The retirement benefit has not been.
What is wrong with this order? We are asking you.
That partly was.
What is wrong with this order? You tell us, we will set it aside right now. You tell us what is wrong.
The ad hoc service period has not been regularized. That's why I have not getting any.
We are asking you what is wrong with this order. This is not that you can raise everything of his service before us. There is an order. You wanted pensionary benefit. The tribunal directed to pay pensionary benefit within 60 days. That order you have challenged. We will set it aside. Tell us what is wrong with it.
But the retirement.
It's a futile litigation, madam. It's a futile litigation. Take down. For the learned advocate for the
19.
19 million I am for the respondent. 19 I am for the respondent petitioner wife.
My lord, I am for the husband. You are for the husband. What is the issue? The issue, my lord, the wife files, my lord, petition for divorce under section 13(1) of the Hindu Marriage Act. It was granted on the ground of, my lord, cruelty. Now, my lord, if your lordship kindly see, my lord, the order, my lord, the marriage is of, my lord, 2012. Now, the wife left the matrimonial home, my lord, in the year, my lord, 2012. My lord, thereafter, in 2018, the matrimonial suit was filed by the wife. My lord, so far the allegations are concerned, my lord, I could not see, my lord, there is cruelty upon the wife, my lord, which has been agitated by the wife in her, my lord, plain, my lord. The learned court, my lord, if your lordship kindly see, my lord, from page 34 of the paper book.
This is the earlier order passed by us, calling for the TCF. The assignment. The assignment. Will also not receive. Where is the assignment order? It's the assignment.
Assignment.
That's the
The mediation against
Assignment order to go which way?
Yeah. You are challenging the decree of divorce. But that is the assignment is there. No, we wanted to see whether it is assigned to your lordship.
To me or the by name, so it is with the presiding. If I am presiding, we can take it up.
Now, my lord, the main point which was agitated in the, my lord, plain, my lord, is the ground of cruelty. But nowhere from, my lord, I could get, my lord, that is cruelty upon the wife. My lord, lordship kindly come to page 34 of the judgment. Paragraph 22 and 23. She was, as per her, my lord, awardments, my lord, she was driven out in 2012. She was subjected to torture, not a single affair, not a intimation to the police station, my lord, there was torture.
But to substantiate the ground of cruelty, my lord, she has to prove, my lord, that was cruelty upon her. Not a single scrap of paper was, my lord, adduced, my lord, as evidence. But before the learned court, we were to substantiate that fact. And 2012, she was alleged to have been given out, and 2018, she's filing the matrimonial suit, my lord.
My lord, may I place my submissions?
No. Just bear with us for a few minutes.
As your lordship pleases.
Now, my lord, kindly come to the deposition at page 21. I'm sorry, my lord, 21 is my deposition. Right.
Oh, shit.
Page 31. Lord, may I read for your lordship? Just give it. Yes. My lord, kindly come to page 14. Page 14 of the paper book. Okay. It is the cross of the lady. Second paragraph, my lord. I left my matrimonial house on 27/7/2012. Since 24/7/2012 till date, I have no contact with my husband. Since leaving my matrimonial house, I did not lodge any complaint on the police against my husband. It initially also starts from this, my lord. I did not lodge any complaint to the PS or to the Panchayat about factum of torture on me by my husband to bring money from my parents' house. I have no document to show that the OP demanded money from me or I was tortured by him for non-payment of money. I completed my BTech engineering degree staying at my parents' house. I joined my service such and such date. I tendered my resignation. During pendency of this suit, I had no contact with my matrimonial house. My father-in-law died after marriage. I was about the dates.
And where is your deposition?
Yes, my lord, my deposition is page.
Also page 21.
19
20, 22.
19 is the chief.
My cross starts from page 21.
Ajit Kumar Sood. Anup Kumar Sood.
My lord, page 22 is the, my lord, evidence of the cross of the, my lord, husband. Appellant, my lord, here it. And my lord, kindly see, my lord, at page 18, my lord, this is the cross-examination of the. My lord, this is the cross-examination of the sister-in-law of the, my lord, the appellant, my lord, at page 18. Matrimonial house of my sister is situated at a distance of 2 kilometers away. Distance of my matrimonial house from the matrimonial house of my sister is 15 kilometers. My matrimonial house is by the such and such, my lord. We did not inform to the panchayat and we have no paper to show that husband of my sister demanded 1 lakh rupees from her. It is fact that since 27/7/2012, my sister has been residing at her parents' house having no connection with their husband. 2010 marriage, 2011 child, 2012, my lord, she left the matrimonial home. Not a fact. Husband of my sister demanded such and such money, my lord, or he never assaulted my sister under influence of liquor. Well, this is the position of the sister-in-law. So the, my lord, the point of cruelty, my lord, that has to be strictly proved. It cannot be presumed. On presumption, my lord, that cannot be done, my lord. The learned court below, my lord. On presumption, my lord, the divorce was granted, my lord.
So your case is that there is no material to show the
Cruelty. Fine.
Yeah, may I submit, my lord? My lord, the conspectus of this appeal is very short, my lord. My lord, kindly takes up page 6. My lord, the written statement filed by my lord, the husband. So very short written statement, my lord. I read out to your lordship and then, my lord, I'll place my submissions, my lord. My lord, para 4, my lord. that the statements made in para 4 of the petition such and such effect that that after 3 years of their marriage, the respondent used to give pressure to the petitioner to bring such and such from her parents for his business purpose, and the petitioner told the respondent that it was not possible for her to bring rupees 1 lakh from her poor father, and the financial condition of her father was not good to meet up such illegal demand of the respondent, etc., are not correct at all. So, Milord, after that, Milord, para 5, Milord, also, Milord, they have denied and disputed all along, Milord, up to, Milord, para 7. The statements made in para 8, Milord, they have denied and disputed. But, Milord, no specific case has been made by them. Thereafter, Milord, kindly sees para 8. That as a matter of fact, the respondent never caused any physical and mental torture upon the petitioner, and he never demanded any money or gave any pressure to the petitioner to bring money from her father's house. The petitioner did not like to reside. The petitioner did not like to reside in her matrimonial house with the respondent. That the respondent went to the father's house of the petitioner several times to bring her back, but the petitioner has refused to come in. And considering the above facts and circumstances, such as such, Milord, there is no specific statements and assertions, Milord. Milord, no Section 9 application has been filed by the husband for reconciliation, Milord, for restitution of conjugal rights, Milord. And Milord, now Milord kindly sees, Milord, page 2 of my plaint as regards to the cruelty which they are alleging, Milord, that I could not substantiate, Milord. Page 2 of the plaint, Milord, kindly sees. Para 4. That after 3 years of their marriage, the respondent used to give pressure to the petitioner to bring rupees such and such from her parents for his business purpose, and as the petitioner knows the acute financial condition of a poor father, she told the respondent that it was not possible for her to bring rupees 1 lakh from a poor father, as the financial condition of her father was poor and was not sufficient to meet up illegal demand of the respondent. As a result, the respondent began to torture upon the petitioner mentally and physically, and about every night the respondent came to his house with drunken condition and assaulted the petitioner frequently and did not give proper food and clothes to the petitioner. That this kind of behavior by the respondent upon the petitioner treated as cruelty, that this inhuman behavior, the petitioner become ill, and without medical examination of the petitioner, the respondent and his family members forcibly driven out the petitioner along with her minor son on 24/7/2012. Milord, on this line, Milord, there is no cross-examination. They have all along accepted this. If Milord sees the cross-examination for once, Milord, apropos, Milord, page 11. If Milord sees the cross-examination, Milord, there is no specific cross-examination to this part, Milord, forcibly driven out. কোনটা? কোথায়? ওটা আসছে দাঁড়া। Yes. Page 14, Milord, is the cross, Milord, of PW1. Milord, page 14 is the cross of
the law for not putting in relevant question. The cross-examination.
Milord, it will deem to be accepted, Milord, if not cross-examined.
Where is the law?
Milord, that I'll have to produce, Milord. I do not have the judgment with me right now. But Milord, it is there, Milord. If they do not cross-examine on that point, Milord, they have accepted that statement.
So that is the point you are arguing.
Yes, Milord.
You have come without a judgment.
Milord, on that point, Milord, I do not have judgment right now with me, Milord.
The point you are arguing, you should have been armed with that judgment.
Milord, I'll show your Lordship the other aspects, Milord, and then, Milord, I'll come back to that, Milord. Yes. Milord, kindly sees the cross-examination of them, Milord. Page 22, Milord. Of the husband. I have a child begotten through Anandamai. Our child is now 11 years old. I do not know about his school education or even school name and class. I do not know the cost of my child's education. I do not know the present whereabouts of my wife Anandamoy. I do not know even I do not even know the phone number of my wife. The parental house of my wife situates in the adjacent village, Barkunda. I have many known persons in the village, but I have no relative over there. I stopped visiting in-laws' house since filing of the divorce. I was an LIC agent previously. Now I stay in my house without any work. Fact that my wife passed engineering from such and such. Subsequently, she did her BTech from Durgapur. My wife worked at customer care on Airtel. Sometimes such and such, such and such. Thereafter, we lived together as husband and wife. I cannot say whether she still in employment or in service or anywhere. So, my lord, absolute cessation from my lord marital duties, my lord. At the very first paragraph, if my lord sees, my lord, I'll put this question to myself, my lord. Was it a inhuman task for me, my lord, for him, my lord, to know the whereabouts of me? I resides in the adjacent village and my child, my lord. But the child also falls under this periphery of my lord marital duties, my lord. Now, my lord, I'll cite one judgment, my lord, Rakesh Raman, my lord. Out of just duto. हाँ मतलब para 20 मिनट matrimonial cases before the courts but they are living in separation since 2012 मिनट para 20 मिनट matrimonial cases before the courts pose a different challenge, quite unlikely any other, as we are dealing with human relationships with its bundle of emotions, with all its faults and frailties. It is not possible for every case to pinpoint to act of cruelty or blameworthy conduct of the spouse. The nature of relationship, the general behavior of the parties towards each other, long-term separation between the two are relevant factors which a court must take into consideration. Lord, there was no question of reconciliation between the parties, Lord. Even from the written statement of the husband, it could not be inferred, my lord, they wanted to live with me at this moment. He has all along denied and disputed all the allegations, but my lord never showed any willingness to stay with me, not even in the grounds of the appeal. So, my lord, the marriage has broken beyond repair. Do you want summer with that? Good. Page 22. Reducing. Background. Background. Not important. Yeah. Backwards. Like here is effect of the content rather than distinction which is we are very important as the corporate and common here we are telling the matter yeah.
That would be the.
Yes, right. Yeah, good, sir.
For a certain.
Yes. Now, my lord, I'll cite before your lordship, my lord, another judgment, my lord, 2007, 4 SCC 511.
Which paragraph? This
Paragraph 101.
2317 SCC, which paragraph you are relying upon? Okay.
Lord, the Rakesh Kamal. Yes. My lord, I'm relying on, my lord, there are several paragraphs, my lord. One is 20, my lord. Then after that, my lord, 21 to 24. My lord, may I read out to your lordship?
You need not.
My lord?
You need not. Yes, one.
As your lordship. My lord, another judgment, my lord.
This is considered, this judgment is considered.
over here.
Samar Ghosh has been considered.
Yes.
Yes.
Samar Ghosh. That's what I was producing, my lord.
This has been followed.
Yes.
This, in fact, it further evolves the concept
Yes, yes.
from Samar.
Right, right. So these are the two judgments, my lord, I'll be relying on. Hmm.
There is no cross-examination.
And my lord, also, my lord, he could not substantiate, my lord, his denial as well, my lord. If my lord sees the written statement, my lord, those what he have denied, my lord, he could not substantiate that as well, my lord.
Now we can sue the next. For one judgment, you will come back.
So, my lord, I think this should suffice, my lord. But anyway, my lord, I can.
We asked you where is that judgment that once.
My lord, on the cross-examination.
Yes.
My lord, that I should have, my lord, produced, my lord.
You need not. We will consider.
Yeah.
We will consider. You need not.
As your lordship pleases. Character judgment. Yes, my lord. Yes, yes.
We are talking about it and you are not saying.
My lord.
We thought you will overhear and then you will say, still you are not saying. So that's all.
Yes, my lord. That is my submission.
Replies.
My lord, reply, my lord, has, my lord, see what is there. Kindly see the initiation. He has to prove the, my lord, initial.
Your case is
Yes,
that
yes.
there is no
From the, my lord.
cruelty.
My lord.
Merely a submission
My
and
lord,
then
my
the
lord.
conduct also does not
My
support
lord,
cruelty
my lord.
because she has.
These are all, my lord, after my lord, lapse of a certain period of time, my lord, it has happened.
One submission, my lord, I was thinking of making. He meant, my lord, I have lodged a false case against him, my lord, which in itself tantamounts to cruelty.
Where is the case? There is no case here.
Because, my lord, he has denied and disputed, unsubstantiated.
You have to substantiate that.
That is a different concept that you are arguing.
Same.
That is applied where there are criminal cases
Criminal
which are
cases, right.
held to be false,
Malicious.
or malicious, or an acquittal. Then that may be a ground that this false implication may add to the injury.
This means,
That
my
will
lord,
not
counter allegations of cruelty on
Here you are saying that the fact of this application being denied becomes a cruelty, then every defendant will be ousted. Then
I
every
agree with
defendant will be ousted.
I just wanted to make that argument, my lord.
Not the parties. The file is not changing.
Item 28.
Since it has been assigned to your lordship, maybe the respondents are not aware. Well, this matter has been assigned to your lordship because when it was appearing before my lord, the acting chief justice, he was appearing in this matter. So it was assigned, Milord. Will be heard a fresh lordship. So let me put the other side on notice, Milord, because maybe they have missed the list today.
On that day also they were not here.
Milord, I now normally my lord knows my practice. I issue a notice to the other side so that once and for all it can be decided. Otherwise, Milord, addressing my lord the other day.
Have you seen our last order?
Milord, क्या order था बेटा? Milord,
here.
I've दिए दीजिए बात. Milord has, yes, lordship.
Just please show it.
I'm grateful.
মনটা ছিল কি না এই যে
Lordship, upon death, whether the penalty can be imposed.
We asked, that's why we adjourned it. That what is to be done now, he is no more. This is a subsequent development which is quite relevant to the pending issue. So since we are adjourning it, we thought you should see it.
But a new angle is there because Milord, all these days I was fighting that.
All right, but this is an unfortunate development which has taken place. It's a hard fact. What is the effect that you have to tell us?
In my respectful submission, Milord, let me put the other side on notice. Come back before your lordship with.
Take this into consideration. Therefore, we have shown you.
My lord will kindly appreciate contempt application has been filed by the respondent who are the heirs. So, my lord, at least in my lord, since they are not appearing here in contempt,
You are appearing in contempt also.
My lord, but they are appearing. Before the central administrative DRM's personal appearance has been called for. So, my lord will kindly, my lord.
What is the next date fixed there?
Next date, 10th of September. My lord will kindly just, my lord, by way of passing, my lord, records, my lord, that on that particular day till this matter
Today
is
is
not
what date? Today is 12th.
August. But my lord knows when appeal is pending, my lord, contempt may not lie. But my lord, what happens is that learned admin.
There are two views on that. Modern industries says that you comply it subject to result. There are so many views possible.
It will all I will take the view possible for in the benefit of my client. Be that as it
was that view, we understand.
I am not that, Milord.
No, but we are keeping it much earlier. We are keeping it on 18th. Ask him to be here. Let's see what is the effect of this. On that day, if we have to proceed, we'll see what has to be done. Yes.
18th, Milord. 18th, Milord.
18, 19, 20, whatever the day you want.
Lordship will kindly.
Between 17 to 21, you tell us.
20 में हम 21 तारीख को नहीं.
Or 24, 25, so many dates are there. But please examine it from this aspect, whether this event has an effect or not.
Will it be my lord's pleasure to give it on 26th of this month?
There is none to represent the.
Apologize, Milord. It's a lovely feeling theme. 10 minutes.
Everyone.
Your Lordship, I appear for the appellate, the Union of India. Your Lordship, pursuant to the last order, we were required to file the supplementary affidavit. The same is ready, Your Lordship, but certain pages of the affidavit were found illegible and the same had to get retyped.
We are informed by the learned that
Current 22, may please Lordship, I am for the appellate. My lord, that last auction, my lord directed to file paper boy. Ready, paper boy is ready. We have served to other side. It is to be handed over to the court, my lord. It will. Thank you. If they have got, we can proceed.
পেপার করে নিতে পেপার বুকে একটা করে নিন
I'm serving it, let it be on Monday.
এই যে দেখে নিন একটা করে দিন
একটাও করে department
Copies, paper book.
চব্বিশ না
Current 23.
That this matter Mr. Bose was addressing, my lords, that he is on legs before court 30. That may this matter be taken up at 2 p.m., my lord? So this is that matter where disciplinary action was taken against him. That Mr. Bose was addressing, my lords. Not 2 p.m., my lord. But then should we come up next week?
Will kindly fix a date because Mr. Bose, my lord, otherwise, my lord, he's partly argued as short before this bench.
Yes, my lord.
Not this bench.
I'm sorry, not before.
We resume, if that bench resumes, we can commence from where we left.
Very well.
If not, there may be an occasion.
Very well.
Well, then after 2 weeks, a date may be fixed.
Yes. Never adjourned without a date. I have never done it. After 2 weeks.
26th August. It possibly might be a holiday because it's looking red in the calendar. Yes, the 26th August looks red in the calendar. Possibly a holiday. It says in the I'm deeply.
Current 24.
Appear for the respondents. The corporation, lord, is the appellant here.
Mr. Kishore Datta appearing in this matter, my lord.
So he will appear for the
Yes, for the
corporation.
KMC, yes, my lord.
Very good. We thought that perhaps there is none because last day he
This
said,
occasion, no one.
No one. Last day, the learned advocate said, I am returning the brief.
That was for the KMDA. He's a respondent. For the appellant, none appeared. This is Kolkata Municipal Corporation.
So KMDA still is not, we are not sure who is appearing for KMDA.
Actually, change of panel there is, that's why.
But subsequently, my lord, in other matters, KMDA new panel has come into effect and they are appearing. So I will give them a notice. I intimate, but would your lordship kindly, my lord, if your lordship can record, because there are, I think about 7-8 adjournments have been sought. I don't stand in the way for the last 5 months, and the matter is almost an open and shut case because it relies on a division bench judgment of our honorable court, where this honorable single judge has allowed the writ. Now, therefore, I was humbly beseeching your lordship fixes it on another date, maybe with the expectation that parties will come ready for hearing. If your lordship says that, then we can.
What is the convenient date for you?
For me, my lord, any day. I'm ready.
Means both of you.
Achha. Next week, Mr. Doctor, I think, can address your lordship next week anytime.
Yes, we are fixing it on
20th of August. 20th of August.
Puri. 525. I am for the respondent, petitioner respondent. On the last occasion, your lordship directed me to file opposition. This is the opposition.
Yes.
As none appears, lordship. If one copy is ready, I will
Not
File it during course of the day.
in course of the day, I will file it and I will serve other side.
There is none to represent the.
Article 24. I could not appear before your lordship. I need some more time, my lord. Since I am appearing for the Kolkata Municipal Corporation. No, yes, 60.
Call the next.
126.
For the respondent.
How many people will mention on behalf of Mr. Datto? Somebody was already here, sir.
But I'm for the writ petitioner respondent. Now, your lordship has last occasion heard this matter and directed the appellant to prepare legible copies of all documents and also submit to me.
Yes.
They have not.
Where are the copies? Where is the order?
My lord, I am appearing on behalf of the UCO Bank. Mr. Counsel, Senior Counsel is engaged in court number 39.
For filing legible copies, we need a learned senior counsel. Where are the legible copies? Please show us. At least give the legible copies so we can take it on record. What is the writ court order?
You have challenged the order of disciplinary authority, thereby imposing punishment of one time scale.
Lowering one time
One
by
time.
one time scale.
Yes, under trial court
For how? For permanently or for a few years?
for few years, because I was subsequently I was retired during the pendency of the
So minor or major punishment?
it's a major punishment.
Major. How many years?
Was for
Cumulative effect.
accumulating effect.
Yes. So then what happened?
But we preferred a repetition with this honorable court. This honorable court pleased to find that the entire departmental proceedings is lordship null, and set aside the entire.
Set aside the proceeding. Yes, madam. At least give us the documents. We are adjourning it for the day, not today.
Must have.
Item 27. I made an appearance.
Yes.
So maiden appearance has some benefit. I hope the
Maiden appearance of counsel,
yes.
not maiden appearance before a
No, no, no. We counsel before a bench, which is maiden also.
That does not give any weight.
No, there should be development.
From your side was having his or her maiden appearance, then they would expect something.
Law has to be developed. The system has to be developed. Previously, the council made an appearance. Now, the judges made an appearance also is there. But I have to.
The fifth occasion when the matter is being adjourned due to the reason of the authority appellate.
No, we can proceed. If you don't want to oppose, we can proceed.
But yeah, when I could not go through the application, yesterday my lord has given them the two weeks time and 1 week for the reply.
So what order you want us to pass today? Tell us.
But the entire
What do you expect from the court?
the entire service
It has been served on you yesterday.
Yesterday,
You want to file an opposition.
my lord.
You are saying it was filed after a lot of delay.
Yes.
Despite 2 weeks given, they have filed it just yesterday. What should we do? We should not take it on record.
But kindly consider my entire service.
Consider for what order that we are asking you. What is the relief we will give you by virtue of this submission? Unless a submission has a point. So we ask you want to oppose, you tell us you will file it in 2 days, you keep it after in the next week.
Lord, I will only take 3 days time to file.
Right, very good.
3 days time to file.
Settle law.
Next Friday.
Sir, 19 তারিখ হ্যাঁ Item 28.
My lord, this is the case where bank has
unauthorized debit transaction has been done.
Impute order page 73.
And my lord, will kindly see what number page 49. Page number, let's see application.
particularly impugned order, the judgment citation order. In judgment.
Appellant is a bank, that is rural bank employee. Pension started, they have given on the same date, they have deducted my money. Can you see page 49 in the stay application? $1,27,870 on the same day after payment of pension amount. That is 7,23,12,300
commutation amount.
303.
Commutation amount.
That is commutation amount. This is our simple case where we got the pension.
Commutation.
And same date they have deducted from that account 1,27,870.
বুঝে দেওয়া আছে।
Without any correction, without any correction, without any petition.
And they have done without any permission, without any letter, without any consent of the applicant. And there is no such basis of deduction. And similar cases, what have we in?
Paragraph 59. Paragraph 59. Okay. 59.
Recovery based on some order. Your recovery of this amount is.
So the commutation has been done.
No, it has been recovered on 2011-2019. Any order has been issued, why it is that recovery is done?
On that day, excess payment has been made to him.
We are asking you, any order was made?
No, there is a form. Form 9 was there. If any excess payment is made to the bank,
how? It may be excessive payment made to him. It may be amount which is recoverable.
Order the apex court, Miller.
May be an amount which is recoverable. Can you do it without informing him? That is all we are asking.
Form 9 is there, Miller.
You submit the form 9 to the petitioner?
Yes, he submit the form 9 to the bank.
For this amount?
No.
Show us.
For the excess
Please.
amount.
Sir, you please wait. Yes.
In the order itself also.
We are not asking the legitimacy of the amount. We are saying you process the procedure.
Yes, yes.
Can you just deduct some amount from somebody's account like that, or you're
Not,
required?
my lord, that was not done that way, my lord.
So is it permissible? Then tell us.
Yes,
You
yes.
can deduct any amount from
Not
anybody's
any
account.
amount, my lord. Excess amount as per the commutation, it is excess amount paying to the.
Under which provision the bank's procedure prescribes that it can be recovered from the bank account in this way?
Form 9 is there, my lord. Attaching, annexing, my lord, with the.
Now see, again and again we are telling you, please try to understand our query. We are not on whether it was recoverable or not.
Yes.
Whether it could be done without an intimation. Who gives you the right to withdraw an amount from the account like that?
Petition application started in 2019.
We have seen that pension was being paid in April 18.
Yes, ma'am.
Thereafter, under orders of the apex court, he was required to give an option.
Yes.
In 19, he gave the option, then you started making the payment. Simultaneously, you have made a recovery of 127 an odd amount.
Yes.
Now that amount, can you withdraw it from someone's account just like that?
Yes.
Under which provision? From where do you get this authority?
Give me 1 second. madam. Form 9 is there. It is annexing.
We can understand that you adjust it from payments being made, or you say that henceforward it will be recovered in this manner, or will you are required to refund this amount. Can you go in and take it from the account like this? If so, under which provision? Where is the enabling provision to do so?
As per the pension regulation, my lord, they have to file some forms. And in the form, it is really, if the excess payment has been made to the, somehow it is made to the petitioner or claimant, it is, will be refunded. Bank will deduct it.
Deducted from the account.
Well, kindly look into the time and date. On the 20th, 11, my lord, on 7,12,000 it is paid.
We are not concerned.
Well, I
we
just-
have made a pointed query to you,
Yes, yes,
sir.
my
We
lord,
expect you to
Just give
respond.
me 1 second, right?
Yes.
There is form 9.
You are the mighty employer. Therefore, we are asking you.
Form 9 attached to. They are not attaching the form 9, my lord. They are supplying the copy. The next. Form 9 must be there, my lord. There. Yes, attached to. So they have supplied the copy someday.
Without going into the issue of the amount being recoverable or not,
Yes,
we are only on the procedure adopted by.
Under which
It is
provision bank-
sanctioned by which provision? Please
Yes,
show us.
Yes.
Why 127? You should have withdrawn 5 lakhs. Why not 5? Why 127?
Well, that is the calculation.
Which provision enables you to take it from his account? And how the bank allowed you to do it?
Yes, yes, ma'am.
A third party withdrawing funds from somebody's account.
Not third party, my lord.
You are not a third party to his account.
My lord, bank, this is pension account, my lord. He's paid that money to the account and excess payment is made. That's why, my lord, bank.
So you have a lien over his account that you can make a recovery whenever you want. Where is this provision? Please show us.
But he's not annexed in the form 9, my lord, it is our opposition.
The justification for the amount will come later. This is a unique thing we are seeing today.
Same day, my lord.
No, sir, please, you need not, please sit down, please. Don't compound things for the court.
The next form 9 is not here. I mean, attached to. Well, I'm producing the form 9. He's not annexing here.
We have put a specific query to the learned advocate for the
Form 9 to annex.
Yes, 1 p.m. we have set.
1 p.m.
This order lapsed on 18th May.
It has been extended.
Last order. Yes, listed tomorrow under the heading to be mentioned. Give your slip, please. Give your slip, please. Yes. You have got it. So when do you want it? Tell us. After 1 week? As prayed. Yes, the learned advocate for the ওইটা ঠিক আছে এটাতে
Item number 6, my lord.
Yes, what did we do?
Constellation, this much I know. I know nothing more than that.
In fact, perhaps you will not be able
I recuse myself.
Who will appear? Let us resolve this issue so that it is not adjourned again. Therefore, we ask you to be. So you will appear.
Yes, Lordship, we've received instructions also, Lordship.
So we will take it up tomorrow.
Yes, Lordship.
Yes, tell us.
Tomorrow.
Why you are not maintaining the offspring?
But in fact, in the mediation proceedings, our client has stated that yes, she is willing to give 50% of the benefits, but they were not, they did not accept such offer. Number one. On the contrary, they said that they want the full amount as well as the compensation amount.
It's not correct. Can you call the parties?
Not correct.
Can you call the parties?
Lordship, the instructions that I received.
You stand by you. Yes.
Lordship, as to what has been paid. Lordship, the family pension has been paid to the wife.
First wife.
The first wife. Second wife is not entitled. Leave encashment also to the first wife.
Everything.
The death gratuity has been paid in equal shares between the first wife and the 3 children. First wife has a daughter and
the other 2 children from the second.
What has not been paid is the GIS, GPF and the DA arrear payment. That these 3 heads has not been paid as yet. That payment is stalled.
And there is no application from the first wife's side for a compassionate appointment.
That is also there. That compassionate appointment is also there.
What happened on that
That is under process. That is what I find from the instructions.
So you stand that you are willing to share your 50%.
Then let the
Then ask both parties to come.
Yes, Lordship.
Unnecessarily we will be hearing this matter.
Yes.
Because her son or daughter is very ill. So if,
3 major operation has been.
Who is it? Son or daughter? Son is very ill.
Your Lordship had, you can ask, have a talk with your client.
All right, that is history now. Since you are See, now you are informing us this stand. We hope that it concludes at this. At least he can carry on the treatment.
That report will say otherwise.
No mediation report unless it's failed or successful. It does not go into the merits. So
Statements.
It has to be solved. Let the party.
when you go out again, both of you will be making merry and unnecessarily yes. So let's resolve this. Finish it off. We don't want to get into the argument because that treatment is suffering. When is it convenient for your client to come? Let us know at 2 p.m. Both of you come at 2 p.m. Tell us, you find out the date which we can fix it.
Yes, ma'am.
On that day, if this stand which you are saying emerges, then nothing will remain. All other issues will remain as per whatever is. No, you please find out a convenient date when they can come. Inform us at 2 p.m. Any one of you can inform us. Yes. 2 p.m. we'll call this matter. First, this will be called, then we'll move to any other matter. First, we'll call this, then we'll move to any other. First, this will be called first. At 2 p.m.
At 2 p.m.
Appearances at 2 p.m. Not at this time. Yes. Call the next. बुलाओ
I have a talk with my client at any convenient time.
And also time, my lord, 21st or 25th is suitable for her.
What time?
As your lordship fixes. 21st is a Friday.
21st, let them come back to me.
21st at 2 o'clock.
21st, we have anything fixed at 2? One. So let them come at.
Honorable.
Number 29.
Lordship, I'm planning for the petitioner. I'm led by my senior Manavan Sarvadhikari. Lordship, he is unwell. I'm finally praying for not this week.
Again.
Number 30.
I'm appealing for the appellants in this matter. This is appeal by the Union of India. On the last date, possibly, and the petitioner respondent had sought for leave to file a supplementary affidavit. Your lordships have condoned the delay in this matter, madam?
So that is already allowed.
That is allowed, but I have not been served with any copy of that supplementary affidavit. Otherwise, it's ready for hearing, madam. The व्यक्ति की petitioner से no, ये वो तो नहीं, एक तो नहीं.
The punishment is interfered with.
Yes,
By the
madam. He has been set aside and he has been directed to pay, respondent have been directed to pay back wages in the day of his suspension. And the
So therefore, if it is to be set aside, the consequences will follow. You are agreed that it has been set aside.
Well,
if we interfere with that, everything goes.
Everything.
So what on what ground?
Well, there are two grounds which has been set. One is the proportionality matter. Proportionality. I will rely on one judgment. It has been said, the Supreme Court relying on the division bench of High Court has held that the judgment. Well, it has been held that the
disciplinary authority is the best person.
No. In respect of armed forces, my lord, the threshold of discipline is much higher. So, for the same act in any other civil civil department, he may not be similarly treated. So that is one judgment. Another ground, my lord, is that on the same ground, criminal proceedings has been initiated. He has been acquitted, my lord. On that, my lord, in our case, my lord, the main thrust of the was not any criminality, but my lord, he did not discharge his duties properly, my lord. That was on our ground. We had not assigned any criminality to it, but that charge sheet was based on criminality.
What was the allegation in the charge memo?
The charge memo was that he had been allotted some duty. He could not detect some trucks which had passed. Malad. There were other.
Which force? BSF?
CISF.
Oh, so there is a secure area.
Yes,
in
Malad.
that secure area, some vehicle has
Vehicles
entered,
were passed.
and he was on guard at that
He
time.
was on guard. His defense. His defense is that my duty was only for making entry and register. He was sitting on top of a watchtower. One of the defenses is, since I was sitting on the watchtower, I could not have checked the vehicles. Well, these vehicles carry coal or whatever material, in open trucks. The whole purpose of a watchtower is that he can see from top whether it is carrying something or not.
So this was coming out of the installation.
Went out.
So it was apprehended outside.
Outside. It was apprehended outside. Subsequently. Supplementary
affidavit.
Proportionality, I may not argue very.
So what is the material? See, there are two things. What was the nature of duty assigned to him by virtue of being on the watchtower? There must be a group of officers and staff or members of the force standing guard at the same level at the gate checking the vehicles.
That is exactly his defense. That is exactly his defense, that they did not detect. I am not responsible.
So therefore, what is the responsibility under the duty assignment of duty? We had the occasion of looking into it in one of the cases where a person who was standing at the gate, his duty was defined what he is supposed to do. He is supposed to check the entry pass. He is supposed to look into the vehicle. He is supposed to see that the vehicle is not carrying anything offensive. So this was the duty assigned to someone who was standing guard at the gate. Now, what is the duty or responsibility attached to a person who is on the watchtower? Did the force place anything of this kind before the inquiry officer?
But there is a dispute on this issue also, my lord. From the register, he had been given the duty of checking stroke entry. Now, my lord, that checking was subsequently found to be scratched out. Who has scratched out? That has not possibly been dealt with.
So that was produced before the inquiry officer.
Right.
So how anyone can scratch out? It is your document.
No.
The assignment of duty is not in his custody. You are the custodian of that document.
It was based on solely on notation in the duty deployment register of gate number 2. That register was at the gate number 2.
So therefore, he is not at gate number 2. He is on the watchtower.
Right.
So there is.
But the gate number 2, the proximity is there, my lord.
Obviously. He is from where he is, he can see the gate, he can see the road coming in, he can see the road.
As far as I understand, it has not been properly discussed, my lord. As far as I found and understand, my lord, there is a watchtower which will give the first signal whether this is to be checked or not. If it is an empty truck, possibly he will signal from there, the truck will
We
pass.
cannot proceed on possibilities. We have to see what is the material to show that he was obligated to raise an alarm if the truck was carrying coal and the truck was not covered. Or it is his duty to see that nobody scales the wall because he is on a watchtower. Therefore, he just looks at the perimeter. He is not concerned with the entry of vehicles for which a separate force is deployed at the gate. And what happened to those persons who are at the gate?
I presume one of them were একজনকে ইয়ে করা হয়েছিল একজনকে অ্যাকুইট করা হয়েছিল
No, he got the benefit.
হ্যাঁ
Again,
আচ্ছা
share only. Yes.
হ্যাঁ তারপর কি হয়েছিল
He said this was the order to this.
I think he was the head constable. There were other two subordinate constables. They were the same proceedings were initiated against them. Supplement.
Supplement है. Supplement service করছি. কেন? Supplementary all the papers document ছিল না আমি করে দিয়েছি আরে এটা তো পার্ট অফ দ্য রেকর্ড আপনার জানি আমি দিচ্ছি নিশ্চয়ই দিয়ে দেবো তোমাকে
আপনি কি কোনো ডকুমেন্ট
আরে বাবা দিছে বিফোর দ্য কোর্ট তোমার দাওনি সেটা আমি বাকি দিচ্ছি সেটা আমি কপি দিয়ে দিচ্ছি
বলছে বিফোর দ্য কোর্ট কিন্তু আমাদের সেগুলো বলছে
Where is the finding of SSFC?
The SSFC was possibly not conducted.
No.
No. SSFC is in possibly BSF Malada.
Acha. So here there is a proceeding.
Proceeding. Discipline.
Where is the inquiry report?
Inquiry report of the office.
Just 97.
আমার কাছে তো কিছুই তো নেই সবই তো
I just give the list of the documents.
আমার কাছে আলাদা আলাদা সব ভলিউম আছে এক গাদা কাগজ আছে হ্যাঁ 96 এ বলছি 96 এ
চাই না কিছু পড়া আমার দিদা ডকুমেন্ট দিদি দর্শক দিতে হবে
আরে কোথায় তোমার খবর দাও আগে তো এই দেখো 97 কি আছে সব কিছু আলাদা
এই নাও
It is appellant response. Oh,
these are the part of the records they have not given, so I have given. Implement check করে দিয়েছি
এটা এনকোয়ারি
It's a P.
Mhm. Oh, you could deposition.
So currently the statement of everyone is the same. That they were pursuing the vehicle, took a left, went towards gate 2, then took another left, went towards 2A. When it was approaching 2A, they shouted, please stop. Nobody stopped. The bar was, the barrier was open. And it has, in full speed, it has traveled outside the premises.
Well, what I gathered, Malad, from paragraph page 109, Malad.
Yes.
The possibly two persons pursued the vehicle And my lord, they then at some point over they took another turn to intercept it from another side. When they arrived, they saw the truck was present there. Nobody else was there. Then they came back to the gate 2A. Correct. And when they came to gate 2A, my lord, the pass issued to these had been defaced. My lord, this was only done in respect of empty vehicles. In this case,
Perhaps subject to what you will point out, but from what we gathered, somebody saw the truck loading the
yes,
coke. That is the flashpoint of the entire incident. Then he calls up everybody, that is this truck coming, has it come through properly? Then a check reveals that perhaps not. Then they start howling and shouting at these people who are loading, they flee away. Once they have fled away, they started chasing. First left towards gate 2, second left towards gate 2A, then they go out of the premises. Nobody had a chance to check whether there was any pass or there was no pass.
Possibly inquiry report at page 109, 4 and 109, 4 and 5.
Yes.
Especially 5, my lord. As deposed by PW3, PW4 and PW5, they arrived at the gate soon after the departure of the said dumper outside the plant with Natco.
So they have arrived after it has left.
Well,
these 3, 4 and 5 arrived after the dumper had left the premises.
My lord.
So they cannot vouch for anything that happened at the gate. You please see PW 1 and 2.
1 and PW 1 and 2 chased it.
Yes. They were in pursuit. Their statement is at page 97.
Well,
Sorry, 98 and 99. Nobody chased it outside. Once it left, then everybody stopped the pursuit. One is perhaps the AGM. No, he is the RMD. Yes, AGM. He is the AGM.
Well, should kindly see 98.
Was the truck ever apprehended?
Yes, well. Yes, well. That is when FIR was lodged, well.
No, but in this
somebody found it abandoned, possibly, my lord, if I They tried to stop the dumper by shouting at the driver. The driver did not stop. Near the coal building, they took a right turn along a Kacha road, which is shortcut to intercept the dumper near the storehouse. When they reached near storehouse, they shouted at the sentry of CISF at the said place to intervene and stop the vehicle. Though the CISF responded could not reach in time to stop the dumper. If they had reached the road level and waved out hand to stop the dumper, but the dumper did not stop and sped away. Thereafter, they continued to chase the dumper along the road. At about 1740 hours at the Stripper Bay crushing, they came across with Sri Tanmoy Kanti Sardar, AGM RMD, Sri Anindya Ghosh, manager, and Sri Amar Sarkar, junior manager, who were driving towards the spot in the departmental jeep driven by Sri Amar Sarkar. They identified the dumper to them. Immediately, Sri Tanmoy Sarkar and party turned their jeep and followed the dumper. The dumper sped away the section Mill Road toward gate number 2 at about 70-50 hours. The dumper took a left turn from the main road and went toward gate number 2A. Surprisingly, without any checking by the on-duty CI person on the gate, the dumper went out of the plant. The barrier of the gate was open at that time. Men at the gate did not stop the dumper. Gate for checking allowed to go out without unauthorized load of metric tons of the coat. While the dumper was
approaching gate number 2A, a person wearing a yellow t-shirt standing along with some CSA person inside the plant premises. The left side gate waved to the dumper to go outside the gate. Salesman stopped their dumper. The jeep carrying the new officer and the motorcycle reached gate number 2 immediately just after the dumper went outside plant. Went to go out of the plant to chase them, but CSA men did not allow them, telling that they were not wearing helmet, thus could not be allowed. আরে ইয়ে হয়েছিল কোথায়? কি হয়েছিল কোথায় কোথায় লেখা আছে দেখো চার্জশিট দেখো চার্জশিট as per statement over the dumper now. This incident is narrated in the inquiry report, page 110. It is possibly there in PW1's deposition, PW1 to 8,
From height of 15 and 20 feet, how he cannot prevent? Simply impossible.
No, the allegation is it was allowed to enter at some point of time.
No, against him, that's not the allegation.
Charges.
My lord.
Stop and check.
Stopping and checking, my lord.
Why is the charge? Yes, 69, 70 is the way.
Stop and check.
There is no allegation about incoming. Inbound, regarding inbound traffic, there is no allegation. The allegation is failed to stop the
Stop and check.
the loaded dumper. Where's the charge memo? Which page?
Page 69.
Please read page 69 what it says.
The report is page 71. 71 is the report.
Statement of article of charge. No. Statement of imputation of misconduct of
Future 71 is.
71 পড়ছি that on a double performing general shift duty from 8 hours to 18 hours on 10/6/2005 gate number 2 is checking of outgoing vehicles under the jurisdiction of D company had failed to stop and check one number bearing responsive 39/191 loaded with nut coke of DSP management authorized. They required why is the said number passed through gate number 2 at about 17:55 on 10/6 through a loaded dumper chased by DSP management officer by jeep from Super Bay to gate number 2A. Thus the act of of this incident has come out: gross misconduct, negligence, dereliction of duty, being an under officer of discipline force hence charged.
So there is no allegation about inbound.
No.
He has failed to check and stop.
So, my lord, he is saying that only that incident where he allegation is that he failed to stop it at
Stop and check. Check and stop.
check and stop.
Now, whether check and stop can be done by a person who is posted 20 feet above the ground. There is no denial of the fact that he was posted in a tower which is about 15 to 20 feet high. Normally, such towers are erected to keep a vigil on the perimeter because it lies above the boundary, and to see from a distance if there is some threat approaching.
Right.
Where is CW3
But
and Exhibit 10?
এটাতে আছে
হ্যাঁ সব দিচ্ছি
CW3 page double.
Exhibit 10. Can you show us Exhibit 10?
That will possibly be supplementary.
Yes, which they have filed today.
এটা তো মানে নাম্বার
আমি জানি না কোনটা
এটাই হবে এক পেজ 22 এই যেখানে চেক চেক কাটা আছে যেটা
সাইডে লেখা আছে কোথায়
এই দেখো এই যে
Exhibit 5
Exhibit C10. C10.
পেজ 22
22.
ডিউটি সিরিয়াল নাম্বার 4 এইটাই তোমরা বলছো চেক ইনটা কাটা আছে ওটা
উনি এক্সিকিউটিভ টা দেখতে চাইছেন এটা C10 কিনা
আরে ভাই
Perhaps not. We are looking for C10. This is Exhibit 5.
C10 এটাতে এটাই তোমরা রিলাই করেছো যে চেকটা কেটেছে এটা ওই জন্য এটা দিয়েছে হ্যাঁ বলছি আমি বলছি আমি দিচ্ছি আমি দেবো
এক্সিকিউটিভ C10 টা এখানে আছে
Exhibit 10 says duty. Exhibit 10 at Exhibit 11 here.
এক্সিকিউটিভ তো কি তার তার লাস্টে হবে না 69 এর এক্সিবিটও নেই চার্জশিটের এক্সিবিটও নেই এক্সিবিটের কোনো লিড পাচ্ছ দেখ
I'm just, it's a complaint. Regarding cause, see, it's a complaint. Then that pays 5 of the supplement every week. This is the exhibit.
Your inquiry officer relied on these documents. Please see page 111. At the top paragraph, but the charged official simply mentioned in the register as empty out as per exhibit CW3, exhibit C10. This clearly shows the charged official deliberately and intentionally made entry as empty because the said dumper did not stop at gate number 2A.
register.
You have got it?
No, my lord.
Top paragraph.
Top.
Yes. 8th line from the top, 9th line from the top.
An exhibit is empty out.
This is the two documents which the inquiry officer relied upon. That this clearly shows.
The charge official deliberately intentionally made entry as empty.
So whether this constitutes any evidence or not, that we have to see. If it is some evidence, we will not get into it. If it is no evidence, then we will.
And
This will be required, man, because next paragraph also relies on.
Yes, we are. That's why after looking, then only I have asked.
C11, there is reference to C11.
C11 is here. Exhibit 11 is here. I don't know whether C11 and Exhibit 11 are same. I don't know why they are numbering it as C. Where is the charge memo? Where is the list of documents?
Page 80. These have not been marked.
No, it's about 11 at 11.
And where is this duty deployment chart?
This is given.
It is also one of the documents forming part of the
That I shown on page 22.
duty deployment chart.
Yes.
Page 22.
Yes. This is exhibit 11 of supplementary evidence.
This is of which date? 10th?
This is 10 June 2009.
2005.
This is a date of incident. They have given this.
And where is his name?
4. That's 4. They said this is vehicle checking cross. This is they have taken the adverse position, presumption. Out vehicle checking cross, they have taken entry.
Out vehicle entry.
They said checking.
According to you, it is entry. According to them, it is checking.
So they said my duty is also checking. Even
আর এইটাতে কি দেখাচ্ছিল?
এমপি দেখাচ্ছে এক্সিবিট 6 এই যে গাড়ি নাম্বার গুলো এমপি
এটা তো এন্ট্রি করেছে।
হ্যাঁ এন্ট্রি করেছে এমটি দেখাচ্ছে এমটি
কোন ভেহিকলটা?
এটা
বুঝো না না
We can be allowed.
না কনফিডেন্স একটু কম করো।
And where is his signature at 4? It is the last column or second last column?
দেখি
Page 22.
Page 22 দেখো।
Duty distribution, PM. Then what does it say?
4 no 4. Your document.
These are possibly both their signature. Once when starting of the duty and second is.
No, you have said this is checking is cross, so you have taken the adverse position.
Lordship asked the signature, my lord.
Hmm.
Lordship was asking both signature is supposed to be of the same person, possibly.
In the final order, you have taken the adverse position for this. Presumption it is.
Possibly, my lord, because it is one must be when he is starting the duty, when he is checking out of the duty. Because the previous signature, this is also.
No.
Signature
Maybe appears to be
different.
no, it doesn't. Yes. Similar. No, you appear to be correct in that submission. He is probably giving the time on which he has assumed the duty and when he has left the duty.
You have taken crossing only.
Yes.
You are referring to this case?
এখানে কোথায় আছে দেখো ফটফট করে বলতে হবে।
You have not signed this.
Just sign it.
See, this is in. This is out. This is in. Out.
কোনটা? WB 39
Out.
37.
But this has been explained is 134 in the final order. This
will come to you. Yes.
So there is another because page 21, madam.
Yes, we have seen that. We are looking at it.
Yes, madam.
It says empty.
His register. He admits that he is supposed to mark registers.
Where he has admitted?
No, his whole case is that his job is to enter, make entries.
Yes, so what is this?
So if this is a register, my lord. Now, my lord, kindly.
This is bearing his signature.
Yes, my 216. My lord, kindly see the left column.
But the inquiry officer did not rely on this.
That is the problem. My lord. I do not know if this is C5.
No, it says exhibit 6.
This is the date. It just says exhibit 6.
Exhibit 6. This is the daily outgoing register. Even if we take it that at serial
Well,
2,
it has been marked empty. Against this vehicle.
serial 217 is the relevant entry.
Yes, sir.
WB 391291. It is marked as empty like the other vehicles in that series. At the bottom, it bears the signature of the inspector. On the same date.
Inspector possibly the signs of at the end of the register.
So yes, he has endorsed it. If all of this has happened around 6 p.m., why he should endorse it? If there was a rush and people were chasing and this dumper has fled away, he would not have put his signature there. And after that, his lordship is correct. After that also there are 1, 2, 3, 4, 5, 6 vehicles. 5 vehicles.
5 vehicles. Within few minutes, several 52, 53. Time is out time. 50, I do not know what means. 50, 52, every 1, 2 minutes, one vehicle is.
It's a steel plant. Trucks keep coming in. They are standing in a row, queued up one after the other. From this register, it does not appear that there was a chase and somebody has fled out. It appears
This register proves only one thing, that this vehicle, which was subsequently intercepted, has been marked as empty.
Has left empty or has been marked as empty.
Has been marked as empty.
It can mean either way.
Even if we,
because it was never apprehended inside the premises. There is no proof or photograph showing that it was carrying something.
Right.
So whether actually it left empty, subsequently it was loaded, or it left loaded and it was written and empty, that we don't know.
But there are eyewitnesses who have seen that truck loading and they have subsequently followed that and then they have missed it. At least they have, there is first account, eyewitness account.
Why they all aborted the chase at the gate?
The gate, the persons who were chasing it from the beginning, they tried to be very clever and intercept it.
But they could not, while it was inside the installation, they have tried their best.
Yes, sir.
Finally, they have seen it exit the gate 2A. Then they all stopped.
Afterwards, they have gone ahead and searched it, my lord. Because
it was perhaps detected much later. What is the time of, huh? It was found empty.
It was found empty.
So, the register says empty, it was found empty, so where is the coal?
The inquiry officer possibly said that old dust was found. Old dust was
Obviously, all these trucks in that area, you will find a coal dust.
that it must have been unloaded.
So how
How do you expect him to check and stop from 20 feet above the ground? You tell us, where is the duty details? It is part of the charge memo. We just saw it.
এটাকেই বলছেন এটা কি ডিউটি ডিটেইলস বলে
Photocopy of duty deployment chart of B shift of F company. Please see page 73.
Yes, page 73 मतलब
Yes, 73 of your of volume 1. Just 2 lines above the signature of the commandant. First signature of the commandant. Photocopy of duty deployment chart of B shift.
That's page 20.
Duty deployment register page dated of gate
Page 20 supplement is on.
এইটা কি ডিউটি ডিপ্লয়মেন্ট এটাই sure
No, see, there are 2 things. One is the duty deployment register, which would contain the details of which officer or which member is posted where. Now you come below that.
well at page 22
No, just have a look. Below that, what you have just seen, the duty deployment register. Come below that at page 73. After there is a vehicle number written WB 376352. Just below that, deployment chart of B shift.
deployment chart, my lord.
Yes.
This is possibly the deployment register.
Yes, that is a register
Photocopy
which
duty. No, my lord, there are 2. One at this beginning, your lordship, photocopy of duty deployment register.
Correct.
And then
there is a chart.
Then there is a chart.
So
this at page 22, maybe it is both.
22.
I cannot be sure, my lord. The bottom part is something, my lord. It is either be the chart or the register, my lord. Bottom part of page 22. Here it has been written against him P. Vishwanath, in vehicle entry. He was deployed for in vehicle entry. Serial number 4. But the register charts above it shows out vehicle. He maintain for egulo. কোম্পানি কমান্ডেন্ট দুটোই মেনটেন করে না শুধু এইটা তো ও কেন কেন ভুল লিখেছে হুজ হ্যান্ডরাইটিং ইজ দিস আছে ইন ভেহিকল এন্ট্রি পি বিশ্বনাথ এখানে আছে ওটা 11/6 the second one is 11 incident তো 10 এটা এভিডেন্স দিয়ে কি হয় দরকার কি?
Second one is 11.
11C.
So that is not relevant.
Okay, not 11, 10 years.
So on 11th, he was assigned the in duty.
10 years ago.
কোনটা? না 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 না
এটা তো এটা 11. এগুলো সই করছে।
ভাই আপনি না জেনে বলবেন না, নিচে আছে 10। কোথার জন্য এটা উপরের সিগনেচারটা আমি My lord, will kindly grant me some time to go through this one.
Just now we were
Misleading us, my lord. This is in fact 10. Signature is below, my lord. My friend was kind enough to point it out.
he is not
Above
misleading.
is 11. Second, bottom
He
is
is not
10.
misleading. This exercise is to be done before you come to the court. It can't be done here, sir.
My fault, my lord. Somebody else was engaged. I was.
So just go through it. See,
Yes.
you before above the conclusions of the inquiry officer, he states on which evidence he is coming to this conclusion. First, you mark that. Beyond that, if you find that there is anything which helps you, we will see it. And if those two documents constitute evidence of any significance, then you may raise the plea of limits of scrutiny. If they do not constitute any evidence, then also you may raise that plea. As prayed by learned advocates,
Item 31.
Lordship, in item 31, I'm appearing on behalf of Union of India. Ms. Amrita Pandey is leading us in the matter. She has legs before the other court. Kindly grant me a short pass over, Your Lordship.
Item number 59. I was supposed to give the reply argument, but not for the newly constituted bench.
we are adjourning all the matters after 2 weeks, so that we may know that you have to start afresh or not. So we'll do the same. The matter was yes, his lordship has a query. He has a query for you.
I am distracted there.
Sorry. Item 32.
32, my lord, may I please, your lordship, I am for the appellant. I have served the reply. My lord, I have made it one copy, my lord. Kindly give me 1 day time, I can make a. My lord, I make a copy and.
Keep it ready so that it can be filed.
Item 33.
No, 1 week time, on account of learned account Somodip Bishwas. He is not well.
But for the appellant,
Yes, my lord.
again, in the last time also he was
My lord, he is suffering since last week.
on ground of the learned advocate, Mr. Sumit.
Item 34.
I'm the appellant, may I file my affidavit of service? Impugned order, my lord, is at page 24 of my stay application. Sir.
So if the period of training is included, then only he will get any benefit. The period of training is excluded, then he will get nothing.
That is probably the not the only issue. That is of course one of the issues, but probably the main issue is, of course, that is one of the issues, and I have to explain. I'll show certain provisions of the RPF rules as well as the act in that regard.
What is the other issue, remaining issues?
Three issues, my lord. First is alleged withdrawal of two advance increments under under which were given during the fourth CPC. The petitioners allege that it was withdrawn during the fifth CPC. Notwithstanding that, after the implementation of the fifth CPC, two other increments were actually adjusted, and it was not really withdrawn. The fourth, they were temporarily withdrawn, and after the implementation, they were again reinstated. I'll just show two paragraphs of the impugned order which specifically says so. But at the end, the impugned order sets aside all the office circulars which have been challenged on the ground that it violates CPC, although no specific provisions of the circulars have been given which actually deviates any of the provisions of the CPC. Nothing of that discussion is there. It's only
Well, that the action violates CPC.
My lord.
Where is that?
I will kindly come to the last. I'm sorry, 46, page 46. Paragraph 43. A statutory rule framed under Central Act, which means the CPC cannot be superseded.
No, which does not mean CPC. The Central Act is referring to the RPF rules.
Even if that is
no, not even if it is referring to that. Therefore, we ask you where you say it is violative of CPC.
I'm sorry. I understand. It is my wrong interpretation.
Yes, there is no such finding.
But cannot be superseded by
The
administration.
court says that the CPC provisions will not override. RPF rule says that the period of training is to be deemed to be in service once he is regularized. If he does not complete the training successfully, he will be out anyway. So there is no question of counting that period. Because he is successful, he cannot be deprived of benefits of the 2-year training period. Once he gets that, he is entitled to 2 more increments. So we don't know how you are trying to segregate the two things, that the increment is a different thing and the period of training is a different thing. So just let's see the rule, what it says about the training period.
I will kindly give me a moment.
Absolutely.
Rule 63.1, may I just?
You are appearing for the writ petitioner.
No, my lord, I'm led by Mr. Sinha.
Why is sitting that side? It's quoted in the judgment, perhaps.
My
Let's see where it is quoted. I have seen it somewhere. You're relying on 63.
63.1 and 63.2.
Perhaps quoted in the judgment.
I'll also rely on a few provisions of the Act as well. Section 2C, 6 and 7 of the Act. Page 41, my lord, paragraph 32, the last portion. May I read out, my lord, if my lord deems fit?
Yes, so 63.1 and 2.
My lord. 63.1 says, subject to sub-rule 2, the period of training includes in-service courses shall be treated as duty for all purposes. The word is duty, my lord. So, my lord, the word duty may not, in my humble submission, subject to correction by your lordship.
And what is this training? This is the training prior to confirmation of
My
the
lord,
service.
my lord, my lord.
So this training is under which provision?
The regulation for training period, that is what 63 says. It is during the training period. Sorry, ma'am.
It is not confined to training. It also includes in-service courses. So the treatment for both is stated in 63.1, but it is subject to 63.2. 63.2 qualifies it by saying that if it is the period of training prior to being included in service, it will be subject to payment of a stipend. So this is how you read 63. What happens after successful completion of the training prior to an appointment? Or where is the rule which says regarding confirmation? Because all these things will be covered by the RPF Act and rules. This will not be covered by the CPC recommendation. CPC recommendation is only whether what is the replacement scale to be given, that is all. And to which class, whether it is based, some reports are from scale to scale. There were some reports which says from a post to post. In the new recommendation, the post was identified. If there was surplus post, then it was to be examined whether it was a need-based post or not. If it was a need-based post, then a pay was to be assigned. So that is not relevant here. What is relevant is how the period of training is to be considered once he has crossed the training successfully. Where is that?
I need to, but there are other aspects of the judgment. If I
We'll
can
see everything after that. First, you clarify this.
I can come back tomorrow.
All right, come back. Not today. Just go through the provisions.
Now there have been 7 CPC. Whether central pay commission is recommending a
If number 35.
do the inclusion. Commission is given the revised pay scale. That now showing the scale after taking consideration price indexing is going into everything the commission of those both policies it should be that scale now. While or there is some reports which say for the course of pregnancy, this for the course of diseases. Recommendation of the government accepts the extent that benefits would supply. If it doesn't accept that issue is not arising in that if she has withdrawn. If he has successfully completed, his service starts from here. This is the training, and this is actual service. If he has completed this successful, then the service will go to his people. If he doesn't, then it stops here itself. So if the moment you become a manager, experience
Before I place the order under appeal, I beg leave of my court to place the facts.
Sir?
I'm placing the facts before I
Lordship,
place the order under appeal.
At this threshold, I must say I'm appealing for the Union of India. I have sought for instructions which is not yet received.
Wait, yes.
The appellant, he was a candidate for selection of constables in Occidental Armed Forces in 2024. He belongs to economically weaker section. And as the prospectus mandates, a candidate belonging to economically weaker section will get relaxation. He applied. He qualified in the written test. He qualified in the physical test. And he qualified in the physical efficiency test. That he belongs to economically weaker section, certificate was given by the district authorities. And after he qualified in all the tests, his documents are, he was asked to place all documents for verification. And he placed all the documents for verification at the time of verification of documents. His document, and one thing, my lord, in the examination, he secured about 67 points of marks. His certificate showing that he belongs to, I'm sorry, man, Lordship, kindly pardon. I put the entire blame.
Already we are live.
Yes, madam. And madam, my certificate showing that I belong to economically weaker section was not accepted. And I was treated as candidate belonging to unreserved category, and in the unreserved category I could not compete. I not kindly see my certificate as page 17. Certificate that I belong to economically weaker section. But this is valid for the year 2023, 2024. And this is signed by the additional district magistrate, Nodia. On the basis of this certificate, I claim the status of economically weaker section. Then, my lord, kindly see for a moment the prospectus. The prospectus at page 29, last date and time for receipt of online application is 31st of December 2023. Then, my lord, kindly see for a moment page 34, point 6.3, crucial date for claiming SC, ST, OBC, EWS, economically weaker section, status will be the closing date for receipt of online application. The closing date is 31st of December 2023. My certificate issued on 3rd January 2024, and it is valid for the year 2023-24.
This date is 31/12. Well, even if he had the certificate, certificates are issued for a particular. Yes.
You applied as EWS.
Yes.
Where you have stated this fact? You have stated this fact in your writ petition that you applied as an EWS candidate.
No, my certificate is at page 17.
We are asking you, where have you stated in your writ petition that you applied as an EWS candidate?
Yes, madam. That I have stated in the deed petition and also in this petition also.
No. Show us from the writ petition.
In paragraph 16, page 7 of the writ petition.
Please read, sir. Please read, please place it.
Yes, my father. That the petitioner said that although the petitioner submitted the certificate in support of his claim that he belongs to economically weaker section, but his such certificate was not accepted by the authorities.
That does not mean it applied as a
Yes.
EWS. You are now claiming on the basis of a certificate, but in your application you have mentioned where you have stated this fact.
Yeah.
Right.
Yes, madam. In paragraph 10, I have stated of the writ petition that the petitioner states that petitioner belongs to economically weaker section and was entitled to get a relaxation as admissible to a candidate belonging to economically weaker section as provided in the said advertisement for recruitment of constable. The petitioner states that the petitioner belongs to economically weaker section and was entitled to get relaxation.
You belong to this section, you may still apply as a general candidate.
Yes, madam, and my lord, I apply, in the petition, I stated that I belong to economically weaker section.
That we are not asking you. We are asking do you apply as a EWS candidate?
No, madam, in the application, I annexed the certificate.
You did not. Your certificate is after the application. You did not enclose any certificate. The last date of application is 31/12/23.
Yes.
Your EWS certificate is of January 24. There is no question of including it.
Yes, madam, before the date of verification.
Certificate. With the certificate. That is not a correct statement.
Yes.
That's a incorrect statement.
But before the verification of document, I supplied the certificate.
For can you apply as you want and then at the time of verification you say consider me as EWS.
And the prospectus says on the date of verification, the candidates are required to produce the documents.
Very well. That's all.
And madam, kindly see my performance. Madam, in paragraph 12, I've stated that on 1st of October 2024, the petitioner appeared before the competent authority and submitted all the documents, including the said certificate dated 31st January 2024, issued by the respondent number 4 for verification of documents. And then, madam, I will see the judgment under appeal.
Yes.
Some legal notice perhaps.
Kindly see the judgment under appeal as per 89.
Legal notice dated. a letter to the authorities to pursue the litigation. For him, the writ petition has been filed. So, read it from here. Directed to refer to the subject matter. Legal notice is there. Writ petition is filed in the High Court. By this matter, it is stated that certificate seems to be not.
My Lord, kindly see for a moment page 34. That is the paragraph 6.1 of the prospectus. One, candidates who wish to be considered against reserved vacancies or seek age relaxation as required are required to submit a requisite certificate from the competent authority in the prescribed format. Format is also a copy of the format is given in this advertisement. When such certificates are sought by the concerned CAPS for a document verification at the time of DME. At the time of DME, that is document verification.
No, DME is detailed medical examination.
At the time of DME, yes.
DME is detailed medical examination.
Yes. Unreserved. Otherwise, their claim for SC, ST, OBC, EWS category will not be entertained. So, my Lord, my submission is this, that on the crucial date, that is on the date of the last date of submission or application, I possess the status of as belonging to economically weaker section. What I am submitting most respectfully,
we have understood what you are submitting. You are saying the prospectus contemplates submission of the certificate at the time of document verification. I have got the certificate prior to document verification. It is on the prescribed format, therefore I am entitled. This is it. Take down.
My Lord, kindly hear me for a moment. Kindly see the order under appeal.
Yes, we have seen it.
Lordship, kindly allow me to explain in my own way, subject to my Lord's approval. But here, the learned judge has observed that the certificate was issued after the last date of submission of application. That is 31st of December 2023. The certificate was issued on 4th of January.
That is wrong according to you.
That is,
according to you, that is wrong.
No, what I am submitting,
yes,
my status as belonging to economically weaker section does not depend on the date of issue of the certificate.
It should.
No, my Lord, it depends on the contents of the application.
No.
Yes, my Lord, kindly see for a moment my certificate. It is valid for 2023-24.
Very well. Who is disputing that? Nobody is disputing that.
Yes, this is why the learned judge has said, as the certificate was issued beyond the crucial date.
So we should set aside the single judge order.
No, I have come. And another thing is this, that my Lord has directed me to submit a representation before the BSA.
Correct. So we should set aside the.
No, but I am drawing my Lord's kind attention that BSF is not the authority to decide this kind of dispute. That is at page 86. This is the letter from the CIPF authority. That is the CIPF is the proper authority. So I should also kindly direct me to file representation before the CRPF. This is the Under Secretary to the Government of India. Lordship, kindly see for a moment, page 86.
All right.
Oh, here it is. I am that is relevant to subject mentioned above this writ petition and to enclose herewith a legal notice dated January 15, 2025 connected with WPA number such and such by Sukanta Mondol, the appellant paper, my lord, regarding acceptance of BWS economically weaker certificate dated January 3rd, 2025 in the constable exam 2024. It is stated that the EWS certificate dated 3rd January 2025 submitted by the petitioner seems to be in order as per extant rule. Then, as per the MOU signed between the Minister of Home Affairs and the Staff Selection Communication, the representation, litigation, court cases pertaining to PST, PAID, GB, DME and RME will be handled by the nodal force, that is CIPF. The instant matter pertains to document verification. Therefore, you are requested to take further course of action as per the provisions of notice of examination. So, madam, instead of BSF, kindly allow me to file the petition before the CIPF.
Yes,
Lordship,
that's all.
Just one submission, Lordship.
Yes.
Lordship, we come to page 37 of the application.
Yes, sir.
The clause
37.
37. I'm showing there was a window of opportunity given.
That is
Clause
not
10.
relevant. That is not relevant in his case, unfortunately. What is relevant is at page 34, 6.3. Yes, take down. Heard the learned advocate for the
Pending applications also disclosed.
The next one is also this.
What is the date? What is
Same date.
certificate of same date? Let's see the file. Once you go, then we'll have to start fishing out everything from the file. Yes. Same, he's saying same. There also this certificate date is 3rd January.
Yes. That is January, and the order under the application is also on the same date. And my lord, the document verification on the same date.
Alright, just keep the earlier file, just one minute, keep the earlier file.
Same appointment, same.
And where is your certificate in this case? Which page?
Lordship at page 17.
17. So same. Send this file to his lordship. Thank you. We have got it. Thank you.
Even 37.
37, my lord, I appear on behalf of the respondent number 5.
My lord, I beg to appear for the appellants, my lord. My lord,
I believe
One of us.
Item 38.
Not this matter for reasons obvious from the record.
Your Lordship, I'm appearing on behalf of Advocate Gunjan Kumar Singh. He is not in court premises because of high fever, Your Lordship. I'm paying for a week's accommodation.
I'm appearing for the reform.
সাতাশ করে দেয় সাতাশ আট করে 39.
59, my lord, I appear for the appellant, my lord. This is that matter. My other side was there just few minutes before. He is also eager to do the matter. I am also eager to the matter, my lord. Is there, my lord? Yes, he's coming, my lord. If your lordship sees the last order, my lord, this matter, my lord, where I said, my lord, that the condemnation delay was for 41 days, report was 52 days, my lord. Your lordship is pleased to direct me to file an affidavit, supplementary affidavit, my lord. Pursuant thereto, I have prepared, my lord, a supplementary.
So total 52 days.
52 days, my lord.
So come to the merits. Let's see what
Yes,
is the
my lord. Merits, my lord, on that day, your lordship heard me. Justice Roy was not there, my lord. That's why no, I do not have a very good case. So, well, only 2 points, my lord. One, I was beseeching before your lordship on that, my lord. It's only that for a medical test, my lord, that's a ossification test, because we, my lord, tested him twice and we found the same age.
that one where thrice he was.
Yes, we tested him twice, my lord. On both counts, my lord, he was found of the same age range, my lord.
Please start afresh.
Very well, my lord. Let me start it, my lord.
I'm not thinking that.
Yes, ma'am. Now, my lord, the father of the writ petitioner, my lord, he was an employee under us, my lord.
Just give us the date when he passed away.
He passed away on 14th of January 2021.
14 January 21.
On the same date, we provided him with provisional employment because there was tremendous pressure of the union. We had to, my lord, and subject to, my lord, conditions that later on all the procedures are to be followed, and subject to his coming through those procedures positively, then he will get the appointment, my lord. Thereafter, my lord, as a part of the procedure, my lord, his age assessment was done on 24th of May 2021, which is at page 56 of Can 2.
This is the first one.
The first one. It was assessed, my lord, between, if your lordship says, between 35 and 40 years. So the mean age comes to 37.5 years.
Which clause you are reading?
My lord, page 56, my lord. This is the report of the medical.
Oh, that it is boxed in a box.
Yes, in a box. He was otherwise found fit, my lord, but the age was assessed between 35 and 40 years. And date, my lord, on the top right.
28/5.
Yes, my lord. It was given, but my lord, on the bottom right, my lord, it was 20 test was conducted, my lord. Your lordship will see 24/5/2021.
That is the date of the reports and all that.
Yes, date of the report 28. 24/5 is the
report and examination, and the final assessment report is of 28/5/21.
Now, my lord, after getting this report, my lord, so what we did, the provisional appointment which was provided to him, we terminated it while later dated 9th of July 2021, which is at page 42. Is at page 42.
40.
page 42, and the communication is at page 43. Communication to him at page 43. Tenth of July 2021. So the communication.
And when he was provisionally appointed?
On the same date, on the date of death of his father, that is 14th of January 2021. It is at page 36. The letter is there, my lord, giving him the provisional employment. Now, after this letter of 10th of July 2021, he approached the authority, his age assessment by the Apex Medical Board, because there is a provision also under the mines rules, my lord, that for review of the age assessment by the upper authority, higher authority. So, age assessment by Apex Medical Board. Now, so in that, my lord, age was assessed. If your lordship kindly comes to page 59, the Apex Medical Board. That the blur copy.
Again in the same.
Same. And my lord, kindly see the date. It's more or less 2 or 3 between 2 and 3 months, my lord. The
No, it's of November.
November, and the my lord, age assessment, preliminary age assessment, my lord, which was, my lord, it was in money.
Is it?
Yes, my lord, kindly see.
Investigation X-rays of date 19/11/2020.
Yes, November 2021, but the first one.
That was of May.
May.
So 6 months.
6 months only.
Yes.
Okay. So, my lord, the same age, 35 and 40 years. So, we did not recall the letter by which we terminated his provisional appointment.
Yes.
Now, thereafter only, my lord, the writ petition was filed. Now, in this writ petition, there was an order for ossification test. Pursuant to, my lord, ossification test was done. Now, my lord, we challenge that, my lord, I must be very candid before you. We challenge that order
of the writ court.
Of the writ court, that why to send him for the ossification test, because he could not produce any, on the count, my lord, he could not produce any document to
discredit the earlier assessment.
Yes. But that appeal was not allowed, my lord, and rather we were directed to comply with the order of the Honorable Single Judge. Ultimately, that thereafter, my lord, this ossification test was.
Oh, you went before the division bench?
Division bench. Division bench didn't allow this. First, we made a recalling of that order. It was not allowed. We then filed an appeal, my lord. Appeal was also not allowed, saying that how it harms you. So, my lord, so this ossification test was done. Now, after this ossification test was done, my lord.
So then emerges the third report.
Yes, by the SSKM hospital, my lord. It is at page
79.
75. It is at page 75.
So this is after writ petition number?
This is the writ petition against which the order was passed, selling which I have come up before your lordship.
Earlier writ petition, earlier MAT is 1434.
Yes, earlier MAT is 1434. My lord, arising from the same writ petition, but the interim order of this ossification test.
We are asking you the earlier writ. WPA number 22939.
This is the same writ petition. Same writ petition.
This writ petition.
This writ petition. Same writ petition. My lord, interlocutory order for ossification test was passed.
Oh, so
not
that
disposed of. Not disposed of. We preferred a recalling, not allowed. Appeal preferred, not allowed. Thereafter, my lord, automatically this ossification test was made, my lord, done. And thereafter, my lord, this ossification test report is at page 75. It starts from the report, my lord, at page 75, and ultimate the penultimate paragraph or the portion is at page 77.
That the third ossification test. Yes.
Yes. Now, my lord, this page 77, what they assessed on 12th of April 2024. Ours was in 2021. Now they assess in 2024. That is between, because we always counted as our guideline also says that modalities for
So
processing.
3 years, you say 3 years lapsed. So therefore
So no, they assessed him, my lord, 30 and 40 years. That is 35 years on 12th of April 2024. While we assessed in 2021 on 2 counts, 37 and a half years, the median point or the mid age comes to 37 and a half years. We assessed at that point of time between 35 and 40. So we always assess, my lord, the age range of 35 years, because as per our modulation or as per our modalities for processing employment under the NCWA, the age range is 5 years. Here, my lord, this hospital authority, they made it in the 10 years range. But they found him that he was between 30 and 40 years.
Where is this finding? Where is this finding?
Yeah, my page 77, bottom.
So this makes him entitled.
This makes him entitled.
Because he's below 35. Because he's below 35.
Because he was within 35. As at the time of death also. If he is 35 now, so at that time, my lord, 20.
So you have challenged this report?
My lord, report I didn't get any opportunity to challenge there, my lord, because the final order was passed. The final order was passed thereafter, my lord. Now here, my lord, 2 counts. I have taken one plea, and that let him be sent to this AIMS Kalyani, and another plea I was taken which was not considered at all. It's already in my written plea is also there, my lord, against which I will show what they have stated. ECL itself has not been made a party, being a necessary party.
Huh? Where they have not been made a party?
Can you see ECL is not a party here? Who has filed it? Chairman cum Managing Director, ECL. ECL being a separate legal entity. It's a company. Separate legal entity. I have taken this point in my affidavit also. They say it's not necessary.
So that is fatal.
No, my lord.
One authority is represented, then the others are not represented, then it is
the
fatal.
authority, I must say, my lord, that it's not a board or it's not a, my lord, just a organization like that, but it has got a separate entity. Ultimately, whatever the order is passed, direction is to be complied by that entity. The others will, as officers of it, will carry on that order or comply with that order. But ECL itself being a separate legal entity.
So this chairman cum managing director is of which organization?
Of this ECL. Of this ECL. But ECL had to be made a party. ECL was to be made a party, my lord. This is one point, my lord. Another thing, my lord, I only prayed that let him be sent to, because.
But now you are before us. Now assuming that, assuming for a sake of argument that you are a necessary party. So how you are affected by this order, and what would you have done if you were a party here?
My lord, if
that does not change anything.
No, does not change anything, my lord. But
point is the court directed for whether this test of this SSKM is to sustain or not. That remains the only issue.
Yes, my lord, kindly then, my lord, because the tests made by our team, also by the medical experts, on 2 counts, on 2 occasions, and it's not that the first age assessment board found him of an age which is not matching with the age found by the Apex Medical Board.
So where is the interim order by which this third test was done?
Well, probably that order is not annexed, but the order of the appellate court is annexed at page 71.
That order should be in the present proceeding.
Oh, it will not. I have lost my note. The note I finally made, that's why it was a preliminary note. If my other friend can help me out.
My lord, this is the order passed by the single bench, my lord, on the first occasion, while my lord, the ossification test was allowed. Thereafter, a recall.
No, recalling I have said.
Lord, kindly pardon, my lord, I have a single copy.
All right, give it.
And my lord, this is the recalling, my lord, application
No,
file.
not required recalling.
I have said already. Recalling I do have.
Yes.
Yes, so my lord, my point is very limited, my lord. Now it's up to your lordship, my lord, because my only contention, my lord, I don't want to repeat it, but on 2 counts, and thereafter, my lord, this is the 3rd count, my lord. 2 boards decide one board decide something different. So I wanted that let it be sent to this Ames Kalyani. After that, I will have nothing to say.
My lord, this repeat, my father died in the year 2021, my lord, 14th of January 2021. My lord, immediately thereafter, I was provided the provisional employment subject to the condition the medical examination would be held. My lord, medical examination was held. My lord, I was 32 years of age, my lord. If your lordships kindly peruses, my lord, from page 38, my lord, I have annexed the Aadhaar card, PAN card, voter card, transfer certificate of the school. My lord, I have annexed the transfer certificate of the school also, my lord, wherein my age appears admittedly as 32 years, my lord, as on 2021. My lord, they have called me for initial medical examination. Your lordship should, my learned friend.
You were relying upon some contemporaneous documents.
My lord.
Where are those?
My lord, starts from page 38, my lord. This is my writ petition wherein I have annexed those documents.
No, other than Aadhaar card, we are asking you contemporaneous document.
My lord, Aadhaar card. Thereafter, my lord, next page PAN card. Next page, my lord, is the voter card.
Transfer certificate.
Next page is the transfer certificate of the school.
What is the date? But no birth certificate.
Lord, at that point of time.
How many of your claimants come with a birth certificate?
Sir, that, my lord, I tell you, my lord, it's off the track, my lord. I tell you, lordship, what happens in coal mines areas. Many of the persons who come, they pass matriculation or equivalent, the certificates, but they do not say, because they know the moment it is given, submitted, the original age will come into picture. But we know that. We know that, but we don't have any documents, we cannot produce. So
therefore, on a very strong suspicion, then you start doubting everyone.
Not everyone. My lord, what is his age? He says that he was 32 in 2021, and he does not have any birth certificate. Is it believable? I ask it to myself.
Oh, it is very much believable.
And
today, see these people, they are offspring of the laborers.
Everyone has a birth certificate, my
Workmen
lord.
who are working in there in the mines.
And they take birth in the hospitals.
Anyway,
And my lord, the system is now from the
larger
hospital
issue.
itself.
That is a larger issue, not arising for consideration here.
So it's not that, but the age recorded in a Aadhaar card or something, or these documents which he has relied upon.
Nobody can insist on production of a birth certificate for anyone.
No, that I am not saying. I'm not onto that. I say the documents which he has produced, my lord, the age recorded, these are the self-declared documents. Transfer certificate, as your lordship knows how it is.
Thereafter, kindly considers, my lord, page 56, my lord. Age was assessed by the initial medical board as 35 to 40
Page
years.
56.
My lord, in the very next page, my lord, page 57, kindly sees, my lord, the fifth line. He appears to be 33 to 38 years of age.
Experience, not taste. It's some
years of age.
Amy, and this is
The same was quite patient.
I
And this doesn't serve any purpose. Both things, yes.
On very next page, my lord, he appears to be 33 to 38 years of age. The same board, initial medical board, my lord.
Yes.
Now, my lord, kindly considers, my lord, page 59. Thereafter, I have applied before the Apex Medical Board. They have assessed me 35 to 40 years. My lord, my service was terminated on two grounds. First is low vision. That was, my lord, thereafter.
That was subsequently
Set aside by the Apex Medical Board. And my lord, thereafter, 35 to 40 years, my age was assessed. Now, my lord, kindly considers, my lord. My lord, I have, since my lord, my documents was not taken care of, and my lord, they have terminated me service on the ground of overage, my lord. I have filed this writ petition before this honorable court, wherein, my lord, the Honorable Justice Rupita Banerjee was pleased to direct me to go for an ossification test, my lord. My lord, ossification test was held in presence of the ECL authorities. My lord, if your lordships kindly consider, my lord, page 78, my lord, there is the signature of the authorities concerned, my lord. Wherein my age was assessed as 30 to 40 years. Now, my lord, kindly considers the.
Where is the signature? Page 70.
Page 78, my lord. Kindly sees, my lord, my lord, in the bottom portion, my lord. Deputy Manager Personnel, CH Kalla, and Debanando Mitro, my lord, in the bottom, my lord.
Which Kalla is also from first study. I think I've seen that. Yes. So he was there also.
Now, in the initial stage, when the Honorable Justice Rupita Banerjee was allowing the ossification test, my learned friend has prayed for, my lord, to be held at AIMS, my lord, AIMS Kolani, my lord, at that point of time. But since, my lord, SSKM is the independent authority, my lord, it was sent there, my lord. Thereafter, this report has been passed. Now, my lord, what my learned friend is praying before your lordship to send it to the AIMS Kolani, my lord, this was taken care of in the recalling application as well as in the appeal, my lord. Kindly see page 71 onwards also, my lord, which was passed by the Honorable Justice Somen Sen and Uday Kumar. That was turned down, my lord. Now, my lord, they are, my lord, their intention is only to prolong my, my lord, so that I cannot join the post, my lord. My age passes, and they are wanting in their home ground, since it comes under the central government, so that they can have some due advantages, my lord.
That is slightly far-fetched, yes.
My lord, this is my contention, my lord. Ossification was rightly done, my lord. And now, my lord, kindly considers the observation made by the appeal bench in page 73. My lord, the learned single judge, however, did not accept the said submission on the ground that the modalities as referred to are in force for the purpose of facilitating the grant of social benefits to the petitioner. National Coal Wages Agreement is a beneficial piece of legislation when the petitioner is otherwise eligible for compassionate appointment, and there is a doubt with regard to the age no injustice should be caused to the employer of the ECL if ossification test is conducted, my lord. My lord, my prima facie prayer before the lordship was, my lord, to grant me compassionate employment so that, my lord, I am the only breadwinner of the family. I can survive with my family, my lord. My lord, this was the doubt that has been cleared subject to, my lord, SSKM, my lord, has filed the medical examination report.
Yes. Yes.
Yes. And my lord, not only this, my lord, before filing of the writ petition, I approached another independent authority, which is this district hospital at Asansol also, my lord. There also, my lord, I was declared fit for joining. That I have also annexed in the writ petition, my lord. My lord, page 45. That was also there. Thereafter, I filed the writ petition. Thereafter, ossification test was done 4 times, my lord. This was taken care of. And my lord, as far as the submissions made by my learned friend with regard to, my lord, I have not made necessary party, my lord. Kindly consider page 19, my lord. Coal India Limited is a party. Thereafter, I have made all the authorities of ECL a party. General manager, chairman, managing director, everyone. These are my submissions.
May I, my lord, only reply. I am not going to whether whom he has made a party, because he has said that he has made Coal India party. I am not going into all these things, my lord. As your lordship has already said, my lord, it's that one of the authorities of the ECL has been made a party, so it will not make a difference. But I will only show.
But at the same time, your authorities were there during the test in SSK.
No, I'm coming to that. Why? But first I will show. My lord, referred to page 45. Kindly take 45.
That is a naked eye assessment. We have seen that.
Only. That's he cannot say. And page 55 and 56, he said that the same authority assessed my age. It's not same. First of all, my lord, page 56 is the age assessment board.
Correct.
Can you see the doctors, different doctors?
We have seen the other ones, naked eye assessment. It is just on appearance.
And different doctors, different board.
Maybe whatever it is not a scientific assessment.
So far, this report is this. They were there only to identify that person. At the time of test or making the report, we are not there. Whether this person is this petition is not on the. Only to identify that.
That purpose is not specified by the order. The order says you may be present.
We are not allowed to go before the.
But anyway,
in the medical board, no. So we say that this is on 2 counts, my lord. We are on this paper.
Yes.
That on 2 counts, I was also medical experts. Here also medical experts. On 2 counts, 2 boards of us, they held this age range, and here, my lord. So there is a, my lord, difference between the two. So disparity. That's only my my lord, before your lordship.
That's all. What the parties?
Grateful to your lord.
Lordship will see everything, don't worry.
Grateful to your lord.
Yes, my lord, on 19th at 2 p.m. my lord. Grateful.
140.
At 40, I beg to appear for the respondent, my lord. On the last occasion, your lordship has heard the appellants, and if your
Your
lordship,
Lordship, I appear for the appellant, Your Lordship. I was there, Your Lordship, in item 40, Your Lordship. Your Lordship, I am appearing for the appellant, Your Lordship. In this, Your Lordship had adjourned the matter to take instructions on the point, what are the admissible dues? Your Lordship, further, we require 1 week further time to take the instructions. I have seeked for the instruction. I'm awaiting the instructions. 1 week matter may be adjourned.
probably it was not for admissible dues, whether they will continue with the appeal or not, because there was nothing which
You
the,
did not, you were there on the last date.
no,
You
no,
were not there.
Mr. Shukanto
Your
Chakravarti.
Lordship, in this matter, Your Lordship had
Please,
the
no, you please appear with the learned advocate who was there on the last date.
Your
He will-
Lordship, it may be made notable.
Yes.
It may come back tomorrow, my lord. Because otherwise they are keeping it pending for consideration.
Just come tomorrow, yes, not to wait for them.
Grateful.